Boom. Hey, folks, how's everyone doing? I'm going to probably go back and cut that intro down to like 15 seconds because I used to need a longer intro and now you don't really. So I'm going to cut that down to like 10 seconds or something because, yeah, the reason why those intros, why we started all using them is because StreamYard would start up and then kick in at some random time. So we'd start the intro and then we could start the recording and we could know exactly when we had to be live, because otherwise it catches us like midway through a facial expression, or you just don't know when to start talking, which is not good. So I'm gonna chop that down. Now the other thing on video links is that I have two new bumper things that I can show you, but I figure I should show you when they become appropriate. The reason why I have new bumpers is because I was kind of feeling bad that there'd be people who would have they'd give like large number of gift subscriptions, and I didn't have like a thing to play. Like when there's the big super chats, I've got a thing where I can play like sort of a little thank you clip, but I didn't have that for gift subscriptions. So I added one for 20 and I added one for 50, which isn't, likely to come up a whole bunch, but yeah. And I see thank you for keeping me company. Just got some really sad news. Have to say bye to our big boy on Wednesday, and I'm not ready. The thing is you're never really gonna be ready, but it is kind of a nice thing when you can sort of plan it. And the reason why I will say that is that, with our last pup sort of went, we knew he was going, but we didn't know exactly when. And it was really not a good experience, the sort of last bit there. So, DK, just keep in mind, you can be there to, in their sort of last moments. That's going to be what they want, is just to be able to see you. And, that way you can sort of, you can be there for that, sort of last moment. That's, I think, really important. And I see we've got this. Thank you, Shay B. And that means I have to run the new bumper, which is... I like that one. I'm not sure if it's perfect yet, but I kind of like it as an idea. I've got a different one for 20, but I like that one with the with the sort of rose thing. I went with sort of a growing plant theme because we get more green in the chat when there's gift gift memberships. So all right, I hope everyone's got something good to relax with on a Monday. I don't know about you guys. I have been way overworked. I've been working, the whole the whole law thing, but also the whole getting a Supreme Court filing written thing, which is insane, and also trying to get some content out, get some things there. And so yeah. Elf says, did you get your factum out? Yes, I have it. I'm probably going to need to revise it just to get like everything together for it to be properly submitted. But at the very least, the draft is done. It's out. And so it's out the door. So yes, Shay B says, that was lovely. Got a new job and we'll have to leave early. I'll watch the replay tomorrow. Thank you so much, Shay B. And I hope the new job is going great. All right. So, what is it? I see somebody saying, doesn't that count as the whole law thing? Sort of, except that I have the law thing for everyone else, and then I had that for me. So that was the me law thing. Because as much I'm having to hire, counsel for it, but I'm doing a lot of the I'm doing a lot of the heavy lifting in terms of the writing and so forth. So and the case is Runkle v. Canada. It is literally Runkle against Canada. Now, when I say Runkle against Canada, it's not like in the sense of like I am going to destroy the country, but it is that I am fighting the government about things. So that's kind of the thing. Have you been getting any sleep? No, that is not how that works. All right. So, let's I don't know where to start, so we're going to start with Canadian law. Yes, it's Runkle and Canada properly. We're going to start with a little bit of Canadian law because there's a whole topic that has become really, really big in in Canadian discussion, and that is Section 33 of the Canadian Charter of Rights and Freedoms, which is also known as the Notwithstanding Clause. The reason why this has become a big thing is that Poilievre has said he is going to use the Notwithstanding Clause to impose. So right now, the law had been that there was that courts could impose consecutive periods of parole ineligibility when somebody was convicted of multiple murders. And so what I mean by multiple murders is like you have a guy who kills 6 people and they change the law to say, listen, we can impose consecutive periods of sentencing such that this person will serve, not just life with no possibility of parole for 20 years, but life with no possibility of parole for 20 years, and then 40 years, and then 60 years, right? So that was struck down in the case of Bissonnette. And Elf Wiggins says, oh dear, how do you get a good fact pattern to fight that? And the answer is you don't. Bissonnette is a case that is the worst possible case from the perspective of trying to fight this in court. Because in order to fight and try to strike down a mandatory minimum sentence, because Mr. Bissonnette was a multiple murderer. Mr. Bissonnette was also one of the worst people you can imagine. He entered an Islamic cultural center and shot and killed 6 people and then injured 5 others. So he was really the perfect case for getting mandatory stacking sentences, right? Now, Mr. Bissonnette went to court and he said, listen, you imposed a period of parole ineligibility on me that is excessive. What was the period of parole ineligibility that he got? Well, at trial, the Crown prosecutor asked for 150 years of parole ineligibility. 150 years. And that was a whole thing. So ultimately, the court imposed a period of parole ineligibility of 40 years. 40 years. So he then goes up to the Supreme Court, and the issue was basically whether he should get 40 years of parole ineligibility or some lesser amount. And the Supreme Court said, listen, it is unconstitutional. It is against the charter to impose a sentence greater than for one murder. Now, this is a bit of a contentious thing because at the end of the day, what this kind of means is that nominally, after the first murder, every other murder is a freebie. And what do you mean? What do I mean by that? Well, you murder one person and you're going to get you're going to get life with no possibility of parole for, the 25 years. But then you murder 12, and it's still life with no possibility of parole for 25 years. So it's like, why not just commit some more murders? Now, here's the thing. Let's say you've got no possibility of parole for 25 years. Well, the thing is at 25 years, you don't automatically get parole. It's not like, hey, you made it 25 years, out you go. It is, you made it 25 years, you get to ask us for parole. And you're a lot more likely to get parole at 25 years if you have killed one person than if you've killed 6 people. So if you've killed 6 people, when the parole board looks at you, they're going to go, no. So I'm going to tell you, even though Bissonnette won his case, his period of parole ineligibility starts at 25 years, he is actually probably never going to get out, with one possible exception. What is the circumstance in which they might parole him? They might parole him if he has a stroke, or if he is, seriously injured in some way. Because typically when you've got those kinds of people, the only way they get paroled is if they're in such bad health that they are functionally unable to do anything. And that the eventual, that all you're really doing is releasing them so that they can be kept in a care facility instead of a cell. Prisoners who are unable to move and something like that are actually a real pain in the butt for prison officials, because a prison is not built to deal with that. So if you've got somebody who's basically vegetative, it's like, okay, maybe we should put that person, out into, maybe that person we can release just so that they can die somewhere else, right? Because it's really a thing. So that's the issue. Now, what Poilievre has promised is that he wants to use Section 33, the notwithstanding clause, in order to put that law back and to basically allow the courts to say, if there's multiple murders, that then you can impose them, consecutively and have the 40-year period of parole ineligibility. And the thing is if that is imposed, then the issue of whether it's cruel and unusual punishment goes away. The court would say, yes, this is cruel and unusual punishment, but the notwithstanding clause has been applied, and therefore we can't touch it on that basis. So, this is incredibly controversial. Now, the thing is the actual specific thing he wants to impose it for probably isn't that controversial. And what I mean by that is that I think that the average member of the public, if they hear that somebody's committed 17 murders, would probably be like, I'm okay with that person being guaranteed to never get out. I feel like that's where the public would land on that mostly. Now, I'm a defense lawyer. I disagree with that. I think that there should always be some chance of getting release. But, I get why people might have the opposite view. So let's have a look at Section 33 of the Canadian Charter of Rights and Freedoms, which is also known as the Notwithstanding Clause, because the Notwithstanding Clause is the most messed up thing you could possibly imagine. It has been described as uniquely Canadian, which is not a compliment in this sense. What is the Charter? The Charter is the Canadian, if you imagine the Bill of Rights, it's the Canadian equivalent of that. So let's have a look at what it says. I've got the Wikipedia here just to pull up the text because that was easiest. So let us presenty. Here we go. All right, and then I'm going to embiggen, and here we go. So text, Section 3, Parliament or the legislature of a province. So This was actually installed as a Canadian compromise because there was a real question about whether we would include any sort of rights for people at all when we amended the Constitution back in 1982. And so a lot of the governments didn't want to include any sort of rights because they were like, well, if people have rights, that will limit the stuff that that we can do to our citizens. Governments don't like being limited in terms of what they can do to you. So, they end up compromising on this one. That was not the logic. It kind of was, because governments really, really don't like being limited. So we have a whole bunch of rights that this allows you to override, but there are limits. So Section 33 says the Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 to 15. Now, Section 2 is your fundamental freedoms of freedom of religion, freedom of, freedom of speech, freedom of all sorts of fundamental, critical things. But, freedom of expression is the big one there. So, there's that. Now, when we look at sections 7 through 15, 7 through 15 has a whole bunch of rights that should straight up terrify you that the government can turn off. So let's have a look at those. Section 7 is everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So one of the first rights that Section 33 says it can just switch off is literally your right to live, like to be alive. Like your right not to be killed by the government is the first right that they can turn off with this. Section 8, your right to be free or secure against unreasonable search and seizure. That's the right that keeps the government from breaking down your door and looking through your stuff. Section 9, your right not to be arbitrarily detained or imprisoned. So your right not to be like thrown into jail or some sort of camp without some sort of, hearing or the like. Section 10, when they arrest you, you have the right to be informed of the reasons and to be able to contact a lawyer. They can turn that off too. Section 11, your right to be informed when you're charged of the specific offense, i.e., your right to know what you're charged with. Section 12, everyone has the right not to be subjected to any cruel and unusual treatment or punishment. They can turn that off too. They can say, you know what? We're going to invoke Section 33, and you can now, and because we're invoking Section 33, we're going to ban a particular religion. And anybody who is a member of that religion is going to be killed. And I did skip over Section 11, which also includes your right to be tried within a reasonable time, your right not to be compelled to testify against yourself, your right to be presumed innocent, your right not to be denied reasonable bail, your right to be tried by a jury, your right not to be found guilty of an offense unless it was a crime at the time you committed it, your right not to be retried for charges which you were acquitted of, and your right to the benefit of the lesser punishment of whatever happened versus whatever. So yeah, Section 15 is your right not to be discriminated against on the basis of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Now, I saw somebody saying, why would Pierre Poilievre want this to be in the Constitution? Well, he didn't actually put this into the Constitution. That was done by Trudeau. Not the Trudeau you're thinking, not the recent Trudeau. It was done by Pierre Elliott Trudeau, the previous Trudeau. And it's kind of worth noting that when later asked when later they were trying to divide up credit for Section 33, Trudeau pointed the finger at Chrétien, and Chrétien pointed the finger at Trudeau, and both of them were like, hey, this is your fault. So, this is the law. The law says that the government, if they decide to invoke this, can do all of these things. And it is crazy. And I'm saying, but it saved the country. Yeah, they should still get rid of it. I'm a big proponent of the idea that they should eliminate Section 33 entirely. And, because we see this. Runkle, question, could a party use this power to round up political opponents? You bet they could. Not only round up political opponents, but they could also execute their political opponents. You could theoretically decide to... how do I put this in the most shocking way that is not at all hyperbole? If you ignore the fact that there's international law against this, like there's international law that says that you can't do things, the Holocaust could be legal in Canada if you invoke Section 33. Now, and I'm seeing, but you're neglecting the massive informal constraints on its use. Yes. So far, the notwithstanding clause has only ever been used by provincial governments. It has yet to be used by a federal government. This is the first time we're seeing, well, it's not the first time it's ever been discussed, but it is the, it has not yet been used by a federal government, but at any time a federal government could use it. And, this is like saying, listen, I just want to have this shotgun for, and I promise not to use it. Okay, cool. But there are times and places that might not be appropriate. And yeah. The other thing is I don't trust governments. Of all the people to trust with this power, the last one is the government. So what are the formal restrictions on its use? What are the formal requirements? Well, there are some formal restrictions. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such earlier date as may be specified in the declaration. So if you say we are going to have a law that, violates the charter and it uses section 33, it has a time limit. You get 5 years maximum on that. And the theory behind that is that the Constitution requires an election every few years. And so therefore, basically, they're like, there has to be an election in between renewals of all of this. Okay. They can reenact a declaration, and every time they reenact it, it gets, gets subject to the time. So, yes, and they say the Constitution was patriated with all provinces present but Quebec, so that clause became crucially important after the fact. Quebec's separatism would have triumphed without it. However, they should really abolish it now. They should really get rid of it now. So, I don't approve of this particular use of it because I don't approve of any use of it because we should get rid of it. But the thing is that no party is proposing to get rid of Section 33. They all want to keep that power. They all love having the power. They just don't actually want their opponents to use it. And it's kind of... It is crazy, ultimately. The biggest place where Section 33 gets used is Quebec. Quebec has used it repeatedly. In the early days, after the Charter, Quebec passed a law that says we are going to invoke Section 33 on every single law we pass. And the court said, okay, that's fine. You can do that. And then later they gave up on invoking it on every law they passed, but they have used it, for instance, for French language issues. They've used it to ban religious displays at things. So, yeah, and I'm being told I need a goal. What is a good goal? Goal. There we go. So the reason why I mention this is that Section 33 is literally the scariest thing I know of in our law. It is absolutely terrifying. I don't think we should impose it, even if the reason why they want to impose this might actually be popular. Like, even if the public might be like, yeah, we hate those multiple murderers. And, if you're going to pick someone to hate, multiple murderers is a pretty good choice. Then, but no government actually is proposing to eliminate it. As much as Carney is like, hey, I condemn Paul Evra for wanting to use this, he's also not saying that a Carney government would abolish it. And a Runkletarian government would absolutely abolish this. But, yeah. That is, I think, sort of our discussion of Section 33. It is a bad provision. And, the concern people have is that once you use it once, what's to stop it from being used all the time? Well, the thing is once you've used it, never what's to stop it from being used all the time, because once it's just there, people are gonna use it. Eventually, somebody is going to use it. And yeah. All right. So let's talk about, well, I guess we can, let me just swoop. What's a good swoop? There we go. All right. So, apparently Karen Reed might be starting tomorrow. As soon as Karen Reed starts, I will start recaps. And the recaps, we will cover we're going to cover probably it'll just be like opening statements for the initial one. But so where are we at? Well, I'm just going to say, and this will probably be the unpopular statement, I think it is substantially more likely that, it might be next Tuesday I'm hearing. Okay. I just keep hearing different days. Every day I hear not starting till next Tuesday now. Oh, great. I get a week to actually, that is fantastic. That gives me a week to breathe. Not till next week. Fan-freaking-tastic. That is the best news. So, the unpopular thing is that I think Karen Reed is much more likely to be convicted this time than she was last time. Why? Because they've really put their thumb on the scale, because they have a much better lawyer now for the Commonwealth than they did the first time around. As much as we don't like Brennan, as much as Brennan kind of gives us all like a bad feeling, Brennan is a better lawyer than Lally. And I don't think anybody can argue that point, that Brennan is just better at his job than Lally is. And Brennan is keeping the, he's keeping Lally sort of shelved. He is, and he is running things pretty deftly overall. So I think Brennan is a much more formidable opponent than Lally was. And I also think that Brennan has had some wins in terms of what evidence can and cannot be heard that will make it more difficult for the defense to run their case. So I'm just going to tell you, I'm going to call this trial as I call trials. And what I mean by that is that when I call a trial, I will tell you how I think the trial is going. And the reason why I'm giving you guys this warning is because every time I call a trial, when people don't like what I'm saying, when they don't like the possible outcome, they get annoyed. I am just here to call as I see things going, and that's it. I'm not going to tell you what I think you want to hear. I'm going to tell you what I think is actually happening. So we don't know what's going on yet. I'm seeing somebody said mic issues. I don't know if the rest of you are hearing mic issues. I really want to see Alessi, because I think Alessi is also a big wild card, because I haven't seen much of Alessi cross-examining, but I'm a big fan of, all of those things. I'm seeing some people saying, most people are saying no mic issues. Okay, keep it going. Like, how do I put this? Jackson and Yannetti are good. Alessi is good in the scary way. Alessi is good in the sense of like, you watch him do it. How do I put this? There's a video out there of I'm trying to remember his name now. Jerry Michalek. Jerry Michalek fires within 10 seconds, or it's within a few seconds. He fires 10 rounds out of a revolver, hitting every target. Now, and it's something, he gets it done in 4 seconds or something ridiculous, 10 rounds. That is the kind of thing I thought was absolutely impossible to do with a revolver until I saw him do it. Alessi, his lawyering, you watch him and you go, oh shit, that is really good. But the defense always has the uphill battle, because the prosecution can always decide what cases not to bring, right? And so, that is kind of the tough spot here. So we'll just, we'll watch it as it goes down. But I have been asked to cover or to talk about sort of some of the new filings here. So let's talk about that. And I think some of these are kind of nothing, and some of them are kind of something, and but I don't think any of them are like earth-shattering. So the first one here is the unopposed motion of Gretchen Voss for exclusion from the sequestration order. Gretchen Voss is a journalist. She's a journalist. And Gretchen Voss also is on the witness list. Now, it looks like this is one of the really interesting things here. The Commonwealth and defendant have agreed that Voss will not be called as a witness at trial, and enforcing the sequestration order would violate her First Amendment rights. So this I thought was interesting. Both the defense and the Commonwealth have said, we don't actually need Gretchen Voss. We're not calling her. So notwithstanding that she's on the witness list, she should be allowed into the stand, or into the gallery there. She further states that she's a contributing editor for Boston Magazine and has been covering this case since its inception. She was not a party or witness to any criminal activity relating to this case, and her connection only arises from a reporting of news to the public. She turned over the audio recordings of 2 on-the-record interviews, and it's our understanding that the Commonwealth intends to use these portions of the recording at trial. And the only reason she would be a witness is because there are recordings. Now, let's talk about the admissibility of evidence, right? Let's talk about how evidence gets admitted. So let's say I've got a document, right? Let's say, and I'm just, don't want to use that. I'm like, do I have any documents here that are actually something I can hold up on the screen? Nope. So let's say I have a document or a picture, right? I have a photograph that I want to admit at trial. I have to go through certain steps in order to admit that photograph. And one of the steps is normally that you need a witness to say what that is. Because otherwise you show up and you're like, I have a picture. And they're like, what is this picture? And you're like, but you can see it's clearly a picture of the murder. And it's like, how do we know that? How do we know it's not a picture of a painting of the murder? How do we know it's not a Photoshop of a thing? And so basically they would, normally you have to have a witness who goes in there and says, hey, I committed I took the picture, or I am the custodian of the picture. And therefore, and so I know what this is. It's a real picture and I haven't messed with it, sort of authenticity. In this case, they have worked around that by the Commonwealth and the defendant are stipulating to the authenticity of the records, which means she's unnecessary. And by the random selection process, apparently they randomly chose journalists. She won. They had a drawing of the they had a drawing of which people would get to be in there, and she won. She's like, I win. And so she gets to be in the courtroom, and she's like, please let me have the winning that I did. So she has a First Amendment right. Of course she does. Freedom of the press, right? Exclusion from sequestration orders are commonly granted, particularly for non-adversarial witnesses. And yeah. So when they say unopposed, it means they called up both sides. They called the defense. They called the prosecution, and they said, hey, is there any reason to admit me or to keep me out? And they're like, no, we got no problem with that. So Gretchen Voss should make it in. I understand Turtle Boy did not win the draw for the first, period. So I suspect we will see Turtle Boy make an application to be admitted. But the thing is that I think he will be a little more contentious. I think the Commonwealth will oppose Turtle Boy being in the gallery. I think that they will be strongly opposed to that. I don't know if they'll win. One of the other things is that if Turtle Boy has already gotten in, he's filed motions about it weeks ago. I didn't see those. I'm guessing they were opposed. If Turtle Boy has already, he missed the deadline. Ooh, ouch. If Turtle Boy's already testified, then there becomes less reason to keep him out. So, but the Alberts are allowed for closing. Almost certainly. The reason why I say almost certainly he'd be allowed for closing, or the Alberts are allowed for closing, is that it's open court. Just open court. So how can he be made to testify if he has pending criminal charges about the subject matter? Here's how he would be made to testify. They're like, we're going to make you testify. And he goes, I'm going to plead the fifth. And then that's it. So, yeah. All right. The next one is also kind of unsurprising. Commonwealth notice of intention. to introduce extrajudicial statements of the defendant. There is a little bit of stuff we could talk about to this one. So now comes the Commonwealth in the above captioned matter and indicates its intention to introduce relevant statements to the defendant, either without a witness or through a non-percipient witness reader. So they're basically saying we are just going to, we want to introduce her statements. Why are her statements admissible? Well, because normally they would be considered hearsay. However, this is like a hearsay exception, which is that it's a statement by a party introduced by the opponent. Also often called like the confessions rule or the party opponent rule, or yeah. So to admit a statement of a party opponent, there's no requirement that foundation be laid, nor a witness that has personal knowledge of the subject. So basically they're just saying, we want to introduce these statements. Now here's the more interesting part. The defendant has made numerous statements to witnesses, first responders. We already knew they were going to get the first respondent thing. Medical providers. We knew that they were going to do that. This is the I hit him, did I hit him, like that sort of thing there. Family members and journalists, as well as recorded statements on John O'Keefe's cell phone. The journalists is the big one here. The journalists is the huge one because, hey, they want to use like some of these statements that she made in interviews, and some of those might actually hurt her badly. We'll have to see. I don't know yet how Brennan plans to use those, but we'll see. So they say these statements range from the defendant's immediate impressions and state of mind in the minutes and hours surrounding John O'Keefe's death to crafted narrations, sometimes in the presence of counsel. You can see exactly which sort of interviews they're talking about here. That recount for the defendant's version or impressions of events months and years after the event. And let's just see here. There we go. Kurt, check your inbox. So they say all of these statements are ones of the opposing party made by the defendant and therefore admissible. Commonwealth thereby provides this honorable court notice of its intention. Now, what is it? We have signatures, Michael W. Morrissey, Hank Brennan, Adam Lally, Laura A. McLaughlin. They're putting everyone's names on things. And we have the Commonwealth's notice of discovery. Now, this one, I just want to kind of clear up here a little bit. Now comes the Commonwealth in the above captioned matter. Sometimes the things are not always clear. And one of the things that they are noting there is the copy of the Canton Audit Report. 206 pages for the Canton Audit Report. Now, what I have heard a number of places, including on Twitter and so forth, is people saying, why is the Commonwealth calling the Canton Audit Report? And the thing is, they probably aren't. They probably aren't calling the audit report themselves. They might. But the thing is that they would be required to disclose it. Even if they thought the defense already had it, it is just a good idea to turn it over. And so they're turning it over, right? They don't want to have a situation where the defense stands up and says, why didn't you give us this, right? Why was that not given? And yeah, so copy of Keeper of Records, Unsolved Productions Incorporated episodes, ABC, expert contracts and payments, CVs, Ian Whiffin's PowerPoint video report, interview statements. So yeah, that would be instant Brady if they didn't turn it over. Absolutely. And if they don't turn over the audit report, the defense is absolutely going to stand up and be like, why didn't you give us this? We want the charges thrown out. Why, So that's obviously not something they're going to risk. So not a lot of earth-shattering news here. Not a lot of nothing momentous has happened in the past few days. So I don't think that there's a huge sort of sea change on this. But I am kind of looking forward to, to sort of when this gets started. And we are at 7 out of 10 on the goal. We have Runkle has a pseudo Caesar. I have my pseudo Caesar partially made. And I am just waiting for you guys to hit the goal on that before I start it. So, all right. So let's talk about. Oh, yes. And I should also remind everyone, please like the stream, share it with your friends, subscribe to see more of the things. And hey, Kurt, how goes?
Hello. How are you?
I'm doing all right. Do you want to talk about some lawyers behaving badly?
I would love to talk about lawyers behaving badly.
So there was an email that went out in Alberta for you guys probably get these too, where they're like, this lawyer has been suspended. Everyone needs to know this. And the thing is that those emails are actually really useful because once it was the other side of a case. And so I got to walk in and the other side walked in with their lawyer. And I was like, I am really surprised to see my friend here today because I have a notice from the Law Society indicating that they are suspended. And I got to say that in full view of their client. It was a civil matter. And the other side was like, I haven't checked my email today. And they checked their email and were like, Your Honor, it appears that I cannot actually appear in this matter. I have been suspended. Now, the suspension was only for non-payment of fees. Like, you just forget to send in the money, and then they suspend you automatically. But it's a suspension. And so the judge was like, well, was actually a master in chambers, but they were like, well, I obviously can't hear this with the suspended lawyer. I'm going to adjourn this for 2 weeks, but I'm also going to direct costs for the fact that Mr. Runkle had to show up ready for a hearing with the suspended lawyer. So they ended up having to pay like $500 for the lawyer to have been suspended. And we ultimately lost the hearing, but when it happened properly, but it was still funny. You got to check those. But this was not the one that they just sent out today was not for non-payment of fees. It was first of all, it was for a student at law, which is not a full lawyer. In my jurisdiction, when you pass law school, you're required to do a week as a student, a year as a student at law. And it looks like we've hit our goal. So I am going to crack open a Lucky and add it to my pseudo Caesar here, the Beezer or whatever you want to call it. But
I thought maybe it was a law student who was practicing, because some states allow for that under some circumstances.
So here there are some circumstances where law students can practice under direct supervision, but you go from law student to student at law to lawyer. And so you have to be really clear about whether you're a law student or a student at law, because otherwise you can get yourself in trouble with that.
It strikes me as humorous that there's a difference between those two things.
Well, student at law is sort of an official term for like this apprenticeship period. It's in legislation, it's all this stuff, but during that time you can function basically as a lawyer with supervision with respect to stuff that is of less serious nature. And so, for instance, you can argue bail, and you can appear in docket court, and you can even run trials on low-level matters.
Fun.
Like, I ran a trial on impaired driving as an articling student. And it was a complicated impaired driving. We were arguing all sorts of charter issues. We were arguing all sorts of rights issues. It was a case that involved police brutality. It involved whether they used the breathalyzer correctly. It involved all sorts of complicated stuff. And I actually ended up having to do written submissions on it. But you can do that as an articling student. And but you can't, for instance, like run a murder.
No murder?
No murders. No.
What if it's just a little light murder?
Still no.
Okay.
So, but this guy was suspended for unauthorized practice of law.
Mhm.
What is it? I put the whole list up on Twitter here, just so I get it right now that I'm trying to remember that it's from memory. Suspended for dishonesty to his firm, wrongfully converting money for his firm, unauthorized practice of law.
Did he steal the client money?
And dishonesty with the Law Society. Now, it's wrongfully converting money from his firm. So it looks like he didn't steal the client money. He stole the firm's money.
Okay. Well, that's not as bad, I guess.
Well, it's probably what saved him, because he got a 20-month suspension instead of a absolute prevention from ever practicing. But we don't have that decision yet. I'm wanting to cover that decision when it comes out. But instead, I saw another one that I thought I would cover. There's also an issue out in Ontario that I would love to get your thoughts on.
Okay.
So, out in Ontario, there was a set of murders that were they were called the bathtub murders. And when I say like bathtub murders, it's got like a Wikipedia entry. So basically what happened is these two sisters decided they wanted to kill their mom, and they wanted to kill their mom in order to get insurance money. And so what they did was they got mom super drunk, and then they drowned her in a tub. And so it took a good long time for, like, initially this was just flagged as an accidental death. They basically said mom got too drunk and she died in the bath.
Yeah.
The problem is the usual thing happens when people, commit a murder, which is that they can't shut up. And June Sidlauskas, I saw that you are celebrating a sobriety milestone. Congratulations. Now I feel bad for the fact that I'm having a drink on stream, but 45 anniversary of sobriety. Good for you. And don't let me be a problem. So anyway, one of them confessed to a guy. He said, "We killed our mom." So the police put a wiretap on the guy.
Good.
And then the guy, they got video, they got audio that let them get searches. And they found other like confession stuff. So they were convicted of first-degree murder. And they got sentenced to 10 years. And this was under the YCJA, the Youth Criminal Justice Act, which seals their names. I don't know their names, but if I did know their names, I couldn't tell you what their names were, because it would actually be a crime for me to tell you their name. Now, here's the fun part. Here's the real interesting question. One of these girls has now gone to law school. And she wants to become a lawyer. And so in the process of that, they're required to report any issues that might determine whether or not they are of good character, because there's a good character requirement. And so they're like, hey, I just have to report one little thing as to, what might not be good character, which is that we were convicted of first-degree murder. And so now there's a really interesting question as to whether or not the Law Society of Ontario will admit them to becoming a lawyer. And so I'm just wondering your thoughts on this one. Should the murder girls or the murder girl get to be a lawyer?
Well, I've certainly heard of people convicted of murder being admitted in the United States before. I can't speak necessarily to the circumstances under which that's happened. So, how old were they at the time that these murders happened?
I'm just trying to see if I can find that here. They might not have released that specific detail because.
And how old are they now? Are they like fresh? Are they like 25 or something?
No, I mean they had time to get released and to get So yeah.
I guess I would need to know more, at least in principle, about exactly like what their role was in the event and sort of their, how much they were part and parcel as opposed to the mastermind. Did they hold them down? Were they a mere accessory? I suppose if I want to adjudicate this in a fair way, I suppose I need to know more information.
They were like the whole masterminds. They were the whole like they planned this out. There was another guy who was convicted of a conspiracy because he provided pills that they also used to help with the killing. But they did the killing, and they apparently planned the killing, and so they got the most serious sentence on that. So,
I mean, I guess I would say no if it were up to me. If I were, God for a day, I'd say no. No murderers can be admitted to the bar. So murder feels like a disqualifier.
They apparently were released in 2009, 2010.
Okay.
So they've been out for 15 years.
Okay.
And I don't think they've been in any trouble since then. So I kind of lean towards maybe they should.
I kind of lean to the fact they only got 10 years is ridiculous.
That was the maximum sentence possible for a youth,
which is also ridiculous. I look down on your country.
Canadian sentencing is much lighter, but especially youth sentencing. Now there are provisions to allow people to be tried as adults, but I don't think they use them in this for some reason.
We use them all the time. We love that kind of shit.
Yeah, I always just kind of think that's yeah. I don't know.
You're talking about a pre-planned murder.
It was a pre-planned murder.
So it's like, well, how much moral cognizance do you need to know that the pre-planned murder is bad? Right? This isn't some sort of youth, got out of control and, did something stupid. This is the pre-planned murder. So, maybe I'm an unduly harsh person, but I'm like, you're 14 and you did the pre-planned murder. It's like, you're morally conscious enough to me, that it's like, screw you. Maybe I'm just a harsh guy.
Yeah, I mean, it's tough. I just don't know. And I also kind of wonder, like, what kind of law would she be doing? Because, maybe if she's doing like, wills and estates, maybe there's not a whole.
Well, she's got to specialize in homicides, right? Because she has practical experience, right?
I mean, the thing is
I've been where you are is one hell of a tagline for an attorney.
If I had let's say I was hiring a junior criminal lawyer, right? Let's say the channel starts pulling in like $500,000 a year, and I'm opening up the Runkle of the Bailey firm, and there's going to be like 3 lawyers underneath me, and we're all doing work for free. And I'm looking at like, who do I want to hire to do this work for me for free, for representing people? and going, I'm going to pay this person a whole pile of money in order to lawyer for me. And I've got 2 applicants, and one of them has been in jail. I can tell you that person is moving up on my list, not down. Like, so long as the Law Society has said, hey, this person can practice, I'd be like, this is absolutely somebody who's going to be in a much better position to talk to my clients than I will. Because, I can empathize with my client when he's like, yeah, jail sucks. But you know how many days I've spent in a jail? 0. I mean, unless you add up all of the, the time visiting clients. I've got a friend who's a lawyer in Seattle, and he specifically hired a guy who, when he put on his resume for past experience, he put down used to deal drugs. And he was like, you don't have a record. The guy's like, no, I was good at it. But, and he's apparently this big black guy with tattoos that go up his neck. And so, and apparently at one point, a very odd, somebody mistook that lawyer for the client just because of stereotyping. They assumed that the big, scary-looking black guy would be the accused, and so they pointed the finger at the big, scary-looking black guy who got to get up and be like, "Identifying defense counsel for the record." And no, he wasn't a decoy. He was at the he was at the lawyer table, and they pointed the finger at the lawyer, and he's like, "Okay." Their client apparently got acquitted, even though they had the actual person on video, and the actual person was a skinny white guy. But because the victim,
that's a bad idea. Then that's a pretty bad idea.
Oh yeah, it was pure. This guy has some racism going on. All right, so, but I found this other case that I kind of wanted to talk about, because I thought it was kind of an interesting story of how lawyers can get themselves in some shit without necessarily thinking about it. So, let's just put ourselves here. So this is the case of Bud McDonald. I don't know this guy, by the way, but
Bud McDonald's a good name.
So he is accused, or he was determined, that he brought the administration of justice into disrepute by distributing an intimate image without the consent of all the persons depicted in the image in an affidavit of records, and that such conduct is deserving of sanction. So, what happens in this case? Well, client of his commenced a proceeding in Court of King's Bench against his former partner, who retained counsel and filed a statement of defense. So they're having I'm not sure if it's a family thing, probably a family thing, or a lawsuit, or whatever else. And Mr. McDonald served his client's affidavit of records as required by the rules of court, along with the producible documents identified in it on the complainant's lawyer. One of the producible records identified in the affidavit of records was a photograph which depicted the client, or Mr. McDonald's client, the complainant, and a friend of the complainant. In the photograph, the complainant was partially nude. So counsel for the complainant strongly objected to the inclusion of the photograph and raised the issue with the lawyer. It's like, hey, why are you putting nudes in this document? And so he defended his decision to include the photograph, stating that it was relevant and material to an issue in the ongoing action, which had been raised in an affidavit filed by the complainant in a separate proceeding. He noted that the complainant alleged that she'd been sexually assaulted by his client on November 3rd. His client advised him that the photograph had been taken on the same day, and that such a photograph therefore served to contradict the complainant's evidence that she was R-worded that day by his, and calls into question the complainant's allegations of abuse. And he said that it was not distributed publicly and had provided to her as legal counsel only. So, and he said that agreed to remove the photograph from the affidavit of records while reserving the right to seek a ruling on its relevance and materiality from the court. So basically, he's like,
Okay.
yeah. So
All
he
right.
admitted
I have
that
to I have to pause, and maybe I'm not completely understanding the fact pattern correctly, and if I'm not, forgive me. But I'm not 100% sure I understand exactly what the problem is, because it seems like, based on what I understood, that the lawyer is providing this information in a professional capacity relevant to an ongoing dispute, and this is evidence in that dispute. So I'm not quite sure I see the problem. Am I an idiot?
well, this is the issue: is what is the reasoning for this? What is the concern about this? And there was a previous case that was Law Society versus Harrington, where somebody else had filed a nude on the public court file. That was a much bigger case, like a much bigger issue, right? Because they
No, I
in
could
that
see I could see the problem in putting it on the public court file. I could see that being a bigger issue, because then it's being distributed in the open, and that's a bigger issue. I can see that.
it's
Yeah.
much more serious, right? But they also had another recent decision where, in a family law proceeding, there was explicit video which was made available to several individuals in the litigation. So basically, there's an issue here. What this says is you cannot distribute these photographs, full stop, period, even though they might otherwise be evidence. And for lawyers, this is actually something that is potentially extremely contentious.
Yeah, I mean, there might not only be legitimate reasons, but potential necessary reasons for
Yeah.
me to be able to disclose it. I at some point I'm going to have to disclose it potentially, because let's suppose that you hire me to be your lawyer and you want to sue someone for distributing images that are unauthorized. The image itself is obviously a core piece of the information. So someone's going to have to exchange to someone else a copy of the image, right? Because it's like, well, what is the image? And so what are we talking about? So how am I going to do that without disclosing? How am I supposed to do this? I don't get it.
Now, here's the other thing is that within Canadian law, that image is presumptively irrelevant to the question of whether or not that person has been sexually assaulted. And so what the court determined, because the photograph itself was apparently a topless selfie.
It's on the same day, right?
It's on the same day.
Well, I don't buy that either, because if assuming it happened after the assault, then the condition of her body might be very relevant information as to whether the assault occurred. I don't get it.
And this is the thing: is what they've ultimately found is that he should have spoken with the other side's lawyer to come to a mutual agreement about how to treat the photograph in a sensitive manner. And I can tell you, I can see what you're like. How do I put? I can agree that it might be relevant in the sense of, like, if she says that she was punched and then there's no bruising where she says that should be bruising,
Yeah.
you could say that photograph is clearly relevant to show that there's no bruising there. But that seems like the situation where you might have to have a discussion and say, listen, instead of like us tendering, like, I have a photo, your client knows what this photo is. Let your client know I have the photo and that it doesn't show the bruising. Can we just admit that there's a photo that exists that doesn't have any bruising without actually... The court in Canada has taken a very, very strong stance on this, to a degree that if I am, if I have possession of nudes or anything like that, there's no damn way I'm using them. And I don't even
All right,
want...
let's make the fact pattern even more explicit. Let's suppose that the claim is specifically, he punched me in the chest, and you're my client, and I have a photograph of you topless from what you maybe went to the ER or whatever, and it shows exactly the bruising. And like, I'm gonna have to disclose this at some point. And it's also like, let me show you the photo of my client with the bruising on her breast, so you can see that she's not just making this up. So here's the picture, so you can see that. I mean, that seems like a plausible choice as an attorney. And like maybe there's a different way to go about it, but the question is it unethical or illegal for me to do it that way? I don't see it.
That's probably a situation where they would, for instance, say, maybe then you'd have a like a court hearing, and the court might say you need to disclose the picture, but like edit it down, right? Like, okay, you're gonna like put on a Photoshop bikini or something like that.
Well, if I put on a Photoshop bikini, I'm blocking the very thing I'm trying to present the evidence of.
It depends where it is, for sure.
Yeah.
And it might be one of those things where there might be a good reason for one side to just admit it, right? Because if my client is the one who has the nude and like I can see the bruise, I might tell my client, like, listen, here's the options.
And maybe she didn't go. Maybe she didn't go to the hospital for whatever reason. Maybe she snapped a photo for her own. Just took a photo herself, and so all she has is the selfie that she took, and that's the only evidence. I can't disclose that now. What is this bullshit?
Not. And the thing is, I don't think it's necessarily bullshit. This case, like this decision, really puts lawyers, at least here, on notice that you have to treat these things very carefully, and that you have to absolutely try to take steps to sort of see what you're doing. Now, I will note there are some other sort of things at the end. His punishment on this one was a reprimand, which is basically they just say, you did wrong, don't do it again. He had to pay $1,500 in costs, which is not much. And that's, they always make you pay the costs. But they also specifically say there will be no notice to the Attorney General and no notice to the profession, which means we're not recommending he be prosecuted.
Yeah.
And we're not recommending anything else. So they really do identify this as an oops, rather than him being a sort of, a bad person. And the reprimand itself, they say, Mr. McDonald, you've admitted guilt on one citation, which admission was found acceptable by this panel pursuant to Section 60 of the Act, which basically is we accept that you're admitting this, and that's fine. The nature of your actions in this matter reflect conduct which brought the administration of justice into disrepute. Yeah. We as lawyers must represent our clients vigorously, but must exercise judgment both in relation to the determination of records that are relevant and material in litigation, and they found that this one wasn't relevant or material, and in relation to the use of discretion in providing intimate images to opposing counsel in that context. You acknowledge responsibility for this conduct through an admission of conduct deserving of sanction.
Yeah, I don't buy it.
Views this as a one-time lack of judgment and a long and unblemished legal career.
Yeah, I don't buy it. No. I don't buy it. And for some people in chat asking, like, why are you bringing up hypotheticals? It's not this case. Is because the rule is
that's
not.
How lawyers argue.
Yeah, it's like not the rule. The rule apparently is like I'm not allowed to share intimate photos, and so I'm like, okay, well, what if this was the fact pattern? And then people were like in chat, but that's not the facts. But my point is, even if it were the facts, I still wouldn't be able to do it. And that's the problem. That's exactly why I'm raising the issue. It doesn't make sense.
Yeah, and that's, I think
there might be legitimate reasons that I, as a lawyer, might want to share intimate images of either my client or of the opposing party. If somehow, some way, I came into possession of intimate images of the other side that somehow, disprove their claim. I was punched in the chest. Well, isn't this interesting? I somehow have this topless photo of your client that shows them that doesn't have this bruising. Let me show it to you so you can see your claim is full of lies. I'm not allowed to do that in furtherance of my client. How does that make any sense? I don't get it.
I think what this case would say is that you would have to tell them, like, listen,
yeah,
I have a photo, and this photo, your client knows what it is. It It contradicts your client's story, but it is an intimate image. And so, what are we doing with it? And maybe sometimes you might have to go to court and just be like, hey, court, I need this. I mean, I've had situations where I've had to go to the court and just be like, I'm asking for direction from the court. You make an application for direction, right? Hey, we have an intimate image. What do you want us to do with it? What, do we have to disclose it? Do we have to throw it out? Do we have to whatever else?
Yeah.
I mean, what the court is what the Law Society here is basically saying is like, you need to treat these things really carefully. And guys, let's not bash Kurt. Kurt is arguing like Kurt is dealing with this in the lawyer perspective of we got to analyze this. And he's not wrong that this is actually a big change from how we deal with things normally. Part of the reason why I think that they didn't actually
a change that, at least in some circumstances, could inhibit my ability to zealously represent my client, because maybe there's a reason that I want to disclose it early. Like if you file me a complaint, like it's like, oh, I'm just going to hit you back with the image that I happen to have that disproves your case in one. I get this case to go away immediately. Here's the lawsuit. Oh, that's really interesting. Here's an image that shows your case is bullshit. Would you like to withdraw now? And I save my client a lot of hassle.
Here's the other thing, which is that in many, many other circumstances, things that might be deeply, deeply embarrassing still have to be disclosed. So, for example, let's say I've got a lawsuit and I'm suing the other party. And one of the things I happen to have in my possession is I know that there was, that there is a, I know where, like, let's say it's a defamatory tweet. And I know that the tweet was sent from a particular phone. And I know that that phone was at a particular location. And I need to tie that phone to that person to say that it's actually them that sent the defamatory tweet. And I can say, I can prove that this person was the person who sent it, because at the time that phone was at, I don't know, a strip club.
Yeah.
And I will bring in, the woman who gave him a lap dance just before he sent that text. That might be deeply embarrassing. It might, in fact, be deeply damaging to him, because maybe he's a married guy. Maybe he's a priest. Like, maybe the guy I'm suing is literally a priest and he's not allowed to be in a strip club. That would be a scandalous thing. Maybe
you got to tend to your flock no matter where they are. Am I right?
But it could also be the other way around. It could be that the person is working at the strip club and maybe their parents don't know. And I still might have to disclose that without. So it's basically putting these intimate images into a special category that is different, even if we have that, even from other highly personal, highly embarrassing information. So I certainly see the argument, and I think that's part of why the court, or part of why the Law Society went very light on the punishment when they said we're just issuing a reprimand, we're not anything else. I think that's partially because they're saying, listen, we are changing the rules, we're changing how this is done, and we want people to know that, but we also don't want to. We also don't want to like burn this guy to the ground. So, well, you want to watch something a little more lighthearted?
Yeah.
You're like, yes.
I took the unpopular position, and yeah.
All right. How do I put us here so that we're not?
This has been a bit frustrating recently. It seems recently I've taken a lot of unpopular positions, so I'm used to the criticism, but it's still disheartening sometimes. Oh well.
Yeah. And guys, we can appreciate that, it's a law channel. Sometimes you're not going to agree with everything, and that's fine. But so this is a member of somebody who's running for government in Canada was noting that their signs kept getting destroyed. And so they decided to set up a sting.
Excellent.
The way they set up the sting was they put up a bunch of signs and they waited in the bushes to see if this person... Now, they had cameras that had caught exactly the person who was destroying the signs. So, yeah. Can you guys hear this?
Yeah, I hear it.
Nice to see you, Alex. Is there any reason why you're smashing all my signs along Steeles?
Yeah, because your fucking party is evil.
Okay, so that doesn't give you the right to smash all my signs.
So let's talk about that first and foremost.
That wasn't a good reason.
You know the thing about don't talk to cops? It also applies to don't talk to guy who is waving a phone at you when he's confronting you committing a crime. Because when he says, because your party is evil, first of all, he admits that he's committing the offense. And second of all, he provides that his reason for committing the offense is a political motivation. Now, I'm not going to get into which parties are evil or not, because I'm going to say there are parties I agree with. There are parties I don't agree with. And you're not allowed to destroy their campaign signs no matter what. This could be the Zool party whose campaign slogan is literally all flesh will be dissolved and everyone will experience 1,000 years of suffering, and you're still not allowed to destroy their signs. So don't admit that to the guy with the camera. It's a bad idea.
This is public property. You're polluting.
It's not. I'm not.
He says, this is public property. You're polluting. Well, the thing is that they're allowed to put up the signs on public property. And so it's not polluting when he's like, but he just says, I understand that it's public property. This guy's doing nothing but confessing right now.
Not polluting. It's not.
Yeah, you are.
No, it's not. Listen, it's not private property. It's public property. You've been smashing all my signs along Steeles. Okay, I've got multiple pictures and videos of you doing it. So, if you disagree with something that we're doing, or if you disagree with something that you don't like in our platform, you're more than welcome to come to the office. You're more than welcome to talk to me about it. Have it.
Now, this is one of the things here is that you, this guy knows he's on camera. The guy who's recording knows he's on camera. And so he is very much being as polite, as reasonable as he can. The other guy doesn't seem to realize that he's being recorded yet, and therefore is not. A
civil conversation, but smashing my signs is completely unacceptable. I think you know that. So it's really unfortunate that you've chosen to do that. Do you have anything to say for yourself?
You want to film him back? That's going to help.
The sign that you just literally grabbed out of the ground, you've smashed all of them. Look, you tossed them back here. You seem to like smashing conservative signs. You claim it's on private property. It's not. So is there any reason?
No, it's public property.
It's public property, yeah, and it doesn't give you the right to smash them.
It doesn't give you the right to put your sign on public property.
Side note, absolutely it does. In most places, they are allowed to post their signs on public property. This is why when you see unpopular candidates, they will have their signs entirely on public property, because you'll get parties that have no support. They're like the parties that are the Zool party. Nobody actually is supporting the Zool party and putting a sign up on their property. So, where do they put their signs? They put it on public land. And so, this guy is just really causing himself all sorts of grief here.
Yes, you're allowed to do that. We're in the middle of an election, sir. So you can absolutely do that.
The look on his face isn't encouraging.
The look on his face is probably going to show up on at a sentencing here.
I'm going to put it on a t-shirt.
Now, the thing is there are usually some restrictions about where they can put signs. But the thing is the parties are very much aware of that. If you've ever done any volunteering for parties, and the thing is I've actually helped put up signs even for parties I disagree with, because it's friends are we're putting up signs. We need a person. I'm sure, that's part of democracy. And I'm just going to say, by the by, I've got my views as to which party people should vote for. I'm not going to tell you what they are on this channel. I talk about it on Twitter, but I also just encourage everybody to be able to vote. And I encourage everybody to go vote, go express yourself, right? You're allowed to do this sort of thing. And Laura M noting, in Ireland, after 7 days of the election, if the party's signs aren't down, they're fined for every sign still up. Same stuff happens here. You can get fined for not taking your signs down post-election. So, yeah. Oh, and if it's your own private property and they put up a sign on your lawn that is not you, typically you can do what you like with it. But the thing you should do is just call the campaign office and be like, there's a sign on my property. I didn't ask for it. I don't want it. And they'll come pick it up right fast. So, yeah. Now, this guy also is not doing a great job of representing his cause because he is really insufferable and is probably not an adequate representative of whatever view he has.
What do you have to say for yourself, Alex?
Your party is evil. Full stop.
So, because you think my party is evil, you like to smash my signs?
No, I know your party is evil.
Okay, so why are you smashing my signs? What does that have to do? Your belief, what does that have to do with you smashing my signs?
It's not a belief, it's a fact. Your party is evil.
Uh-huh.
How do you think this one ends?
I'm expecting him to throw a punch pretty soon, to be honest.
Alf Wiggins says, wait, you can't get rid of something on your own property? Usually you can, but you may not be able to destroy it. It gets complicated. So the better way to deal with it is just to call them to pick it up. So.
Your logic, why didn't you break others?
I have been tearing down every single.
Well, how come the liberal signs don't keep going down?
Because your party is the problem.
Like, I'm the local candidate. You're more than welcome to come talk to me about the issues. Well, I don't think you want to talk. You'd rather
talk to lobbyists.
Okay, well,
because your party works for money.
Listen,
you serve the rich, not the people.
So you can see the spoilers as to what happens at the top. Can you guess where this guy is apparently employed? What do you think this guy does for work?
Does he work for the opposing party?
Nope.
Is he a government official?
Not exactly an official. He is employed at the moment by the government, apparently.
Mm-hmm.
Can you guess in what role?
Does he work for the elections group?
It seems that he's got a temporary job with Elections Canada.
Yeah, okay.
I'm guessing that he is not going to continue in that employment, but Elections Canada always hires a whole bunch of people just before the election for like scrutineering and stuff, and the reports are that's what he does.
I'm pretty confident Elections Canada is very, very nonpartisan. Because that's kind of their job.
Yeah, I'm certain that they will be like, "You're gone, sir. Like, you're out." But they've got him on fast forward here. That's the candidate who signs.
How are you guys?
Hey, how are you?
Good.
How you doing, officer?
Who called?
Hello. We're the ones who called it.
Okay.
So,
What's happening?
And
Yeah.
Literally next to my apartment.
Yeah.
you hear what he says? He says, "I'm literally next to my apartment," and he's like, So what he's basically saying is, "Can't you guys just let me go home?" And they're like, "You don't understand. You are getting arrested."
We have a new temporary home for you.
Yeah, we got to. Now I'm sure he'll get bail, but still. So the fun thing is that if he doesn't get release, he can actually still vote. He can vote from jail. And in fact, prisoners who have been convicted can vote from prison in Canada. That's a fun one. The court has determined that it is a constitutional right to vote and that it cannot be stripped from you simply because of a conviction. Now, they left it open to allow for further laws to ban people from voting. But they said it has to be actually specific to election stuff. So you could theoretically pass a law that says if you commit election fraud or possibly if you tamper with election signs, then you cannot vote. But we don't actually have that law right now. So, yeah.
An idea for the future.
I don't even know if it's necessary. My sort of note there is just that if you have enough prisoners that they actually are changing your election in any big way, then something has gone terribly wrong. But prisoners do actually have legitimate interests, right? Like if you're voting for should prisons suck, then they should maybe be able to vote and say, we don't think that is a thing. The big reason why I support the whole right for prisoners to vote, and again, I'm probably going to annoy some people in the chat here by saying that I support the right of prisoners to vote, is that it prevents the use of the justice system to shape the ballot box. So famously in the US, there were politicians who said we want to ban marijuana and certain other drugs, specifically because we think that they're popular and we want to increase the enforcement with all of those things because we think that they're popular among the other side. And therefore we want to use that to like remove their votes. And I'm like, you should never be doing that. The government should never be thinking, hey, we want to ban something specifically because it will help us win elections because we can remove votes from the other people. So I kind of agree with it. I think that we should let prisoners vote. I think that it is a fundamental, now the one thing people say is how do you keep the prison from becoming its own voting block, right? Where it's like you basically get one campaign seat that ends up just being run by the prison. And the way they do that in Canada is you vote from where you were living before when you got arrested. So if you were living in Edmonton and they send you to a prison in British Columbia, you vote from your home jurisdiction back in Edmonton. And if they can't figure out where you were living, because sometimes you got people who are transitory and so forth, and you didn't really have a residence, then you vote from, I believe it's just where your birth certificate is. So you vote from your birth hospital, basically. It's like, all right. To me, that makes sense. So, yeah. I just thought that was a bit of a fun one. A lot of people shared that with me, and I was like, I kind of want to talk about it. What crimes could he be facing? Well, one is mischief. Mischief is the crime of... So you can commit mischief by vandalism, damaging people's stuff. You can also commit mischief by being enough of an asshole. So let's say I go in, let's say Kurt is running a 7-Eleven. Kurt owns a 7-Eleven. I go into Kurt's 7-Eleven and I decide to be a giant jerk ass in his 7-Eleven. I'm sitting there. I got myself, I've got a beer. I'm shouting. I'm, everybody, like somebody comes in, they want to shop, and I'm like, you suck. I have and I'm going to yell at you. And the person's like, I don't want any part of this. And they leave. And I don't actually break anything or steal anything, but I'm just such a jerk that Kurt can't really run his 7-Eleven because I'm sitting there being a crazy person. It's like, well, that's a mischief. I'm preventing Kurt from enjoying the use of his 7-Eleven by being this crazy weirdo. So that's There's also a bunch of election stuff that basically says you can't damage signs, you can't interfere with that. I don't know if they'll charge him with that or just the mischief.
Mhm.
I suspect just the mischief. But yeah, people are saying like Johnny Somali. Yep, everything you'd be doing would be mischief or yeah. So yeah, that one I just and the thing is that one's a good lesson regardless of whether you agree with that guy or not, because ultimately you can't go damaging other people's signs. Oh, and Marvin, thank you for the 20 gifted memberships. I've been waiting for a chance to use this. I put in some gifted membership bumpers, so that's the 20 gifted memberships one. So.
Okay.
Yeah. I like having those. They're kind of a fun sort of interlude when people do that. And I figure that one is a good one for when people, because, there's more green in the chat. So we've got the green popping up there. So yeah, I don't know. The election is getting crazy. And I'm just going to remind everybody, I feel like this is an important thing to remind everybody, which is that at the end of the day, we can disagree strongly with what parties are going to be doing. But nobody in there is like Hitler. If like none of the Canadian candidates are, nobody's going to be like feeding people into wood chippers or anything like that. What they might do is adopt some policies that will inconvenience you or possibly seriously, harm you. But they're still going to be like within the democratic process. And even the craziest positions that have been taken by both sides, while obnoxious, and I say both sides because the NDP basically decided to cease to exist, but while the parties are taking some really obnoxious positions, at the end of the day, life will go on. And I kind of feel like the best objective is always a minority government where people have to work with each other in order to get things done. But we will see. So take a breath. If you are feeling like you are going to be committing violence or committing crimes over this, please don't.
Good tip.
Like just don't. So I want everybody, and I mean, chat, I've got my views. You guys have your views. Everybody's got different views. We really need to be able to discuss those reasonably without hating each other, right? Without fighting. We really need to be able to have dialogue on that. And I think that's important. So please don't fight with each other. Somebody says, what does a minority government mean? So in the Canadian system, the US system is basically two parties. And it's sort of winner takes all in a very rough sense, because you've got the, you've got the House, you've got the Senate. Those can be split, but you end up with, sort of one side prevails. Canada, you can get a majority government, which is basically that one side has all the power, or you can get a minority government, which is that they have the official prime ministership, but they are reliant on other parties for support. And so in order to pass legislation, so minority means they don't have a majority of the seats. And so if they want to pass a bill, they have to get some other party to agree that that's a good bill in order to get to a majority. And also, if they lose what's called a confidence vote, then that party, then the government falls. So if you've got a minority government, they have to convince other parties that they should still be in power. And so it is better when the parties have to work together, or when, all of these things have to sort of work together. So Winston, I am talking about Canada as opposed to the US. The US has got its own things. And it's really not my business, I guess, to try to, Kurt, do you want to criticize the US government? You're in a better position.
I mean, there's plenty of reasons to criticize any government. You always have a cause to say that there's things about the government you like or don't like. But I would broadly agree with everything Ian said. I think that, we have our political differences. Some of those are pretty extreme. But I think also we need to talk to each other. It's the only way that we can move forward. It's we either talk or we fight. That's sort of the options at the end of the day. And I prefer talking over fighting.
Absolutely. Talking is the better way to go. And also remember, the most fundamental right is the First Amendment, in the US, or freedom of expression in Canada, which is your right to express yourself. The most important expression the most fundamentally important expression that people have is the right to say to their government, you suck.
I noticed one person in the chat said, I noticed that you were really supportive of the election and I wish you'd be more critical of the administration. I'm like, man, you're not tuning into my channel enough. I've had issues with the Trump administration on legal levels. And also, this is an interesting point because I make a point in my own mind of separating my politics from my legal. It's like what I support politically and what I think legally is true are totally different things. So, like, if you ask me, do I support a lot of what Trump is doing politically, my answer would be yes. But if your question is, do I think that there are things that he's doing that are not legal, my answer would also be yes. And I discuss those things sometimes on my channel, much to the consternation of people on my channel who don't want me to say those things, but I think it's true. So yeah, tune into my channel more. You'll see more criticism.
The other thing I'll note about Kurt, and this is both a strength and a fault, is that Kurt has his sort of views and principles regardless of side, which means that as much as you lean in support of one government or another, you will. I haven't actually seen you be the guy who's like the everything my side does is right, which I can commend, right? Because I always ask people, this is a good test for determining if you're talking to a reasonable person, is just ask people what has your guy done that sucks? And if they say, I can't think of anything, or I don't know anything that my side has done that sucks, it means they're really not thinking about it other than as a team sport, right? And politics shouldn't be a team sport of red team versus blue team. It should be about good ideas, good, policies, good whatever. And so, we want to see things like, hey, if your side does something stupid, can you stand up against it? Can you whatever? Because without naming any names, I can tell you that I've seen a lot of people out there who seem to have abandoned their principles in recent times.
Yeah, I've noticed that too. It's been a point of frustration I've talked about with others privately.
And it's just wow, I thought you actually, had principles. And it's nope, full team sport. So, all right, let's talk about something more fun. You want to make fun of a bad lawyer?
Sure.
All right, let's do a swoop and then make fun of somebody who deserves it. All right, so let's look at the case of Laura Owens and Clayton Eckerd. So this is Gingras. Is the David S. Gingras is the lawyer on this one. Oh, and I'm supposed to set another goal. What are we at? Let's see, goal. So Gingras is an interesting fellow. He has been saying that Laura Owens is going to absolutely win this 100%. And I went, are we looking at the same case? Because he is not good. Now, Laura Owens, her sort of thing is that she has had a number of cases where she has said that a guy has made her pregnant. And then she turns out not to be pregnant. The most recent one was Clayton Echard, who apparently was on The Bachelor. And yeah. Anti-gun advocate. Haha, I'm out later. No. Sorry, do you think I'm an anti-gun advocate?
Yeah, which of us is the anti-gun advocate? I'm not. Neither of us are.
I'm not allowed to handle a gun on stream, but if I was, I could bring out like lots of them.
Yeah. No. Yeah. Okay.
You want to know how little I'm an anti-gun advocate? I have a flamethrower in the other room. Okay.
Yeah. Yeah.
Like anti-gun advocate. Do you see what the art in my room is? Like
He's gone to the Gandhis. He's gotten awards.
I've won twice. This is an award for being one of the top gun influencers. Oh my god, this is the funniest thing I've seen in a while, but okay. All right. Or maybe he's an anti-gun advocate. I don't know, but yeah, that's just yeah, I've won against the government fighting for firearm things on many occasions, including cases that are named after me. Like the top case on a particular firearm issue is Runkle v. Alberta, and I'm the Runkle. Like, okay. I hope that person's still around to like see the response to that one, because Johnny Lunchbucket, what's the take there? Pro-gun but felon for drugs in the US, so I can't own them. I think you should be able to. I think that when you've served your time, you should be able to get your gun rights back, but I don't have any power over the US. So, all right. I am not an anti-gun advocate at all. All right. So, Laura Owens, yeah, Clayton Echard was on The Bachelor. And now this is something I think is kind of dumb. This decision does not create legal precedent and may not be cited except as authorized by applicable rules. Not for publication. Oh, Johnny, I see that you apologized. It's all good. It's all good. I just my bad. Love you, Rokal. No, it's all good. Thank you. It was a good laugh, and I needed one, so we're all good. Like, I hate this notion that the court can be like, we are making a decision and it's not precedential. Like, just a one-off. Like, no. This, I hate that. You can't do that in Canadian courts, by the way. In a Canadian judgment will never say this is not a precedential decision, because it's just like, no, that is always the you're making a decision. It is precedential, and you could be overturned, and you could All right. So what was the issue here? Well, he said basically that they had, used the safe harbor requirements of a particular rule of family law, which precludes sanctions. And so therefore they shouldn't have to pay a bunch of sanctions, because the court was like, Laura Owens, you suck. You have to pay a whole bunch of money for losing this lawsuit. So in this paternity action, Laura Owens appeals the trial court's award of attorney fees and costs in favor of Clayton Echard. She argues that Eckerd's failure to comply with the safe harbor requirements of Rule 26 precluded sua sponte sanctions under any authority, and that the amount of fees awarded was unreasonable. She also argues the court committed structural error by conducting its own post-trial investigation into the facts of the case. For the following reasons, we affirm. The post-trial investigation, they alleged, was basically, they said that, I'm remembering here, so I'm trying to remember, that Planned Parenthood is closed on Sundays.
Mm-hmm.
And therefore, she couldn't have gone to Planned Parenthood on Sunday. And she's like, that was never in evidence. So they must have conducted independent investigation. And specifically, they must have conducted independent investigations that included looking up influencers who were talking about the case.
Mm-hmm.
Like, not just independent investigations, but they have to have done all of this, like, further investigation specifically. Now, Gingras also made some particular choices. He mocked the judge by putting in sort of like written falsetto, look, Daddy, I'm a real judge now. Tee-hee. Can you think of any circumstance where that makes sense to put into a filing?
Not particularly.
Yeah. So
Did they
know
put tee-hee in the decision?
He put tee-hee in his.
That's epic.
Of the
That's
decision.
epic. I approve.
It's epic, but it's not wise epic.
Tee-hee. Okay. I'll get better, I swear.
And this wasn't like he wasn't quoting the judge, because of course the judge didn't actually say tee-hee. He just said, imagined the judge saying tee-hee. So, in a tremendously sexist moment. So, they note, we view the facts in the light most favorable to sustaining the trial court's findings and orders, which is just the law. In May 2023, Owens and Eckerd had an intimate encounter. Specifically, it was all like north of the shoulders and south of the nose.
Okay.
Shortly thereafter, Owens learned she was pregnant. And the learned she was pregnant is probably deserves
north of the shoulders and south of the nose. I'm not quite sure how that leads to pregnancy, but okay.
Exactly. So in August 2023, she filed a paternity petition alleging Eckerd was the father. Eckerd denied paternity. In December 2023, the case was placed on the administrative dismissal calendar for lack of prosecution, because basically she filed and then she didn't do shit. Eckerd moved to extend the dismissal date, arguing that he was entitled to an adjudication finding of non-paternity. He's like, I don't want this going away. I want a finding that I ain't the daddy. And he didn't want to have to go on Maury to do it. So he also requested an evidentiary hearing on the paternity issue, attorney's fees, and Rule 26 sanctions. In response, Owens informed the trial court that she was no longer pregnant, and thus there was nothing left to adjudicate, and this case should be dismissed. Now, no longer pregnant has the scare quotes, or has the quotes. So she moved to dismiss the case with prejudice. Eckerd opposed. This is actually one of the weird cases where the plaintiff is like, I want out of this. And the defense is like, no, what's the line from Watchmen? I'm not trapped in here with you. You're trapped in here with me. So, yes. That's basically the line there. Oop. So, he then separately moved for Rule 26 sanctions, basically saying the stupid should hurt, arguing that her petition was filed for an improper purpose, her motion to dismiss was unsupported by existing law, and her factual contentions were not supported by evidence, and did not become supported by evidence after investigation and discovery. Basically, he's saying she made up the pregnancy. Owens responded that Eckerd had not complied with Rule 26 requirements because he did not provide her with written notice of specific conduct alleged to have violated Rule 26, and that she was therefore not afforded time to cure any alleged deficiencies. He eventually moved to withdraw his Rule 26 motion, arguing that there was no reason to participate in the pointless litigation over this issue, notwithstanding his disagreement with Owens' legal positions on Rule 26, because Rule 26 was not the substantive pleading basis for his claims on attorney's fees and sanctions. The court extended the dismissal deadline, denied Owens' motion to dismiss, and set an evidentiary hearing on the issue of sanctions and attorney's fees. You know how pissed off the judge has to be like, you have said you want to withdraw a motion for sanctions. I am denying your request to withdraw the motion for sanctions because I think the stupid really should hurt.
Ouch.
That is an angry judge. So, after the evidentiary hearing in June 2024, the trial court granted Eckerd's request for attorney's fees and costs. We will not let you withdraw. I am giving you this money, whether you want it or not. So, Owens filed a notice of change of judge for cause, arguing that the judge was biased and engaged in conduct that violated her right to due process. That was the Tee-hee motion. The presiding judge denied her motion, concluding Owens had failed to prove by a preponderance of the evidence that the judge was biased or prejudiced. Also in July, Owens moved for relief from the judgment, or alternatively to alter or amend the judgment, which the court ultimately denied. In August, the court awarded Eckerd attorney's fees and costs in the amount of $149,219.76.
Nice.
This appeal followed. $150,000 worth of fuck off. Now, she has had like repeated rounds with the court and repeated rounds with, issues. 150,000 might be what says, you know what? You got to stop it. You got to knock that shit off. Mm-hmm. I also like this. The 76 cents is just perfect. So attorney's fees. Owens argues that because Eckerd did not comply with Rule 26 safe harbor requirements. Oh, I'm seeing things about you getting an echo. We'll fix that. There we go. That'll be fixed.
I thought it was just on my end, but yeah.
No, it's because I've got my audio feeding back in. It's my end. It's my fault.
Blame Canada.
So, on a preliminary matter, we note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorney's fees and costs under different rules. We thus decline to consider whether an award under Rule 26 would have been proper. How do I put this? It's they're like, you argued that this was issued. That didn't actually happen, so it's like, yeah, that is kind of a gentle slap. We review the trial court's decision to award attorney's fees and sanctions for an abuse of discretion, but we review a court's interpretation and application of statutes de novo. So different standards. De novo review is basically, we review this as if this was the first time we've ever heard it. We put no weight on anything that has ever been heard before. Whereas abuse of discretion is actually a very deferential standard toward the trial court. It's the trial court can be wrong, and we will still approve them. They have to be like glaringly wrong before they will find an abuse of discretion. So, yeah. Is that a fair description?
Batshit crazy, but yeah.
Yeah, they got to be batshit crazy. One of the easiest ways to find like an abuse of discretion is when the judge just rules something that is like straight up impossible or just like makes no sense whatsoever. Or if they put something like, what would be a good way to find an abuse of discretion? the trial court says, well, I'm ruling against this person because they're black. Straight up abuse of discretion there. But like no court's ever going to do that, right? Oh, I see
Not
Nick,
often.
Nick in the chat. Bonjour, je vous souhaite une bonne journée. Bonne journée, Nick. I'm guessing that was translated with a translator app, but well done. So Owens argues that because the hearing was set in response to the Rule 26 motion, because he did not file any other motion for fees and sanctions, of course the court sanctioned her under Rule 26. Owens contends a fee for or sanctions request must be made by separate motion. While this is true for Rule 26 sanctions, the same is not true for attorney fees requests under the law or sanctions for litigation misconduct under different law. And they note that the court can impose discovery sanctions under its inherent contempt power.
Mm-hmm.
What does this mean? Courts have a certain amount of power by virtue of being courts. And that means that one of those powers is usually the power to make you pay for being stupid. So let's say Kurt walks into court. And I'm going to use Kurt as an example here because I would never do this. And so I'm going to put this on Kurt as if he would. But let's say Kurt walks into a court and he's just like, Judge, I'm going to go, like, if you don't rule in my favor, I'm going to go out and key your car. For some reason, Kurt decides to say that. The judge could be like, you are not threatening me in my court, and I'm going to charge you $10,000 for, like, threatening me in my court under the contempt power. And Kurt, if he was smart for this, would not appeal that decision. He would just pay the $10,000 because there's no way that's getting any better.
No.
It's the court has the inherent power.
The significantly more likely scenario is, Mr. Mueller, I'd like to invite you to visit our prison facilities for a while.
I feel like that's one where the court would be like, Mr. Mueller's exiting out the back door, and we're going to set the contempt hearing for next month.
Oh no, it's worse than that in the United States because it's direct contempt. They can have this. They can basically have the hearing immediately. It's fantastic as the judge. The judge would be like, yeah, it's basically judge, jury, and executioner. It's like, I literally witnessed you do it right now in front of me. Do you have anything to say? Okay, no. As the witness, I find you now guilty and sentence you to up to 6 months. It's fantastic.
So they can
Bingo, bango, done.
You're spending 6 months in. Great.
Yeah. Don't piss off the judge.
And contempt powers are typically not reviewed lightly. Like they're going to do anything they can to find that the contempt power was properly used.
Yeah.
So nevertheless, Eckerd properly requested attorney's fees and costs under those authorities throughout the litigation. For example, he requested attorney's fees and costs under law based on Owens' unreasonableness in his motion to extend the dismissal date on the inactive calendar and schedule an evidentiary hearing, which was filed before Owens moved to dismiss the case. Eckerd made the same response under law in his reply, as well as an amended response to the paternity petition. Moreover, in his motion to withdraw his Rule 26 motion, he argued that he was entitled to attorney's fees and costs under the applicable laws that they cited, and that his claims for fees and sanctions exist independently of Rule 26. These requests were also repeated with supporting arguments and pretrial statement. You'll notice very different tone here between how they describe Eckerd's counsel's behavior and how they describe Owens's counsel's behavior, which is Gingras, because they dunk it on one side here. Owens argues the trial court lacked the authority to impose attorney's fees and sanctions independently from Rule 26 because Eckerd filed and subsequently withdrew the Rule 26 motion. She maintains that Rule 26 must control and must provide the exclusive remedy for conduct that would fall under a Rule 26 violation. In support of this argument, she relies on the proposition that when two rules deal with the same subject, the more specific rule controls. So, there are a bunch of legal maxims that apply. Oh, good night, Elf. Elf Wiggins. It was Elf Liggins, and then it became Elf Wiggins. There's a bunch of legal maxims that can apply to things. So, for example, when you've got a list, how should the court deal with the list? So if the list says something like all livestock are banned from entering within the city of, Oklahoma, including cows, sheep, goat, horses, and donkeys. And you're like, well, I'm bringing in a chicken. The question is a chicken livestock? Well, the court will look at it and they might go, okay, the examples they give are cows, pigs, all of those things are mammals. All of those things are quadrupeds, all of those things. So chicken probably isn't included because we gave a list of examples that sort of narrows down livestock. So
that seems generous,
kinds of
baby.
Yep, and we have Latin terms for all of them, which is part of why lawyers suck. So, regarding the marriage of Thorn, that actually sounds surprisingly badass. Marriage of Thorn?
Yeah.
Okay. But the statutes under which the court granted attorney's fees do not govern the same subject matter as Rule 26. Section 25-324 governs attorney's fees, not sanctions. And the sanctions for costs and attorney's fees that the court under 25-415 were based on Owens knowingly presenting a false claim and knowingly violating a court order compelling disclosure or discovery, which is distinct from conduct that would constitute a Rule 26 violation. They're separate rules. We decline to hastily find a clash between a statute and court rule, especially when the statute and rule govern different subjects. Owens next argues that the attorney fees and costs awarded were improper because they were neither necessary nor reasonable. She asserts Eckerd's fees were literally $0 prior to November 2023, and if his counsel had simply picked up the phone in mid-December and asked her about her intentions, she would have informed him that she was no longer pregnant, and there was nothing further to litigate.
Mm-hmm.
Now, I can just say there is no way to have counsel fees that are $0. Because if you have, the other side is doing nothing on your file, your lawyer is going to send you a periodic email that says, hey, it's now February. The other side has done nothing. Here's what our approach is, which is probably to continue to wait until whatever. And then after February, March, they will say, okay, here's another email. I have done nothing. And that cost money. And I see people noting he didn't have an attorney then. I don't know if he can get attorney's fees when he doesn't have an attorney. Some places allow it, some places don't. But yeah. Eckerd repeated this argument in his response to Owens' combined motion for judgment on the pleadings and renewed motion to dismiss. Trial court found Owens' motion to be moot and declined to take further action. However, there was a delay in the parties' receipt of the court ruling, and the court found this motion was filed with the belief the court had not accepted Eckerd's motion to withdraw. Okay. She similarly argues that Eckerd's decision to file the Rule 26 motion was the precipitating factor in incurring fees. She contends that if Eckerd had done nothing, the case would have been administratively dismissed without a single dollar of fees incurred by either side. Except he wants the ruling that she lied about this. So therefore, she maintains that even if her petition were unreasonable, it was not the filing itself that caused fees to be incurred, but rather Eckerd's choice to pursue sanctions.
Mm-hmm.
But that administrative dismissal would have been without prejudice, so it would not have precluded Owens from initiating a future paternity action. Nor would that dismissal have been equivalent to the order Eckerd sought and ultimately obtained, that he was not the father in connection with the alleged pregnancy. So if she wanted to trigger that, she could have said, I will dismiss it with prejudice and with the admission that you were never the dad. That would have been more sensible.
Mm-hmm.
At any rate, none of these scenarios posited by Owens have any bearing on the propriety of the fees awarded in this case, as that determination must be based not on conjecture, but what actually occurred. You can't relitigate the other side's litigation unless the other side's litigation is actively stupid. And what I mean by actively stupid is, let's say I sue Kurt. And then I sue Kurt for like scratching my car. And I say, Kurt, you damaged my car. I'm suing you. And then it turns out that like I go back to Kurt and I say, hey, Kurt, it turns out it was actually a homeless guy who bumped my car with his cart. I would like to dismiss with prejudice. And you go, wait, well, I got a whole bunch of legal fees. And I'm like, I will pay your legal fees. And you're like, no, I will not accept the payment of my legal fees and a dismissal with prejudice. I want to go on a defamation case for you having filed this suit. And it's like, Kurt, I have privilege. With the suit, like there's no defamation case. And Kurt's like, nah, I'm going. Then maybe the court could say, listen, we're awarding you the attorney's fees for like the initial lawsuit, but we're not doing it for the whole defamation shit like that. No, you should have just taken the money when he offered you the money, right? So yeah, there's a limit, but it has to basically be that you're doing crazy stuff before, it's not just, I might have done things differently, because litigation has all sorts of strategies and decisions and so forth. So yeah. At the time of Eckerd's request for an evidentiary hearing on the paternity fees, attorney's fees, and Rule 26 sanctions, Owens had not informed him that she was going to move to dismiss the case. And in her response to Eckerd's request, filed simultaneously with her motion to dismiss, she acknowledged that the only remaining issue was Eckerd's request for attorney's fees. So you acknowledged it as a remaining interest. Eckerd objected to Owens' motion to dismiss, arguing her avowal that she was no longer pregnant was insufficient to grant a dismissal. He also requested an adjudication that she was never pregnant, or at least that she was never pregnant by him, and an evidentiary hearing on his attorney's fees requests. Trial court ultimately granted his motion to extend the dismissal deadline, stating the issue of sanctions and attorney's fees remain. Owens does not challenge this ruling on appeal, which is kind of a big thing. If you want to overturn the ruling, you got to challenge the ruling, right? And the fact that the parties incurred attorney's fees because they heavily litigated these issues was within the court's discretion to consider, and not something this court will reweigh. Here, the trial court found Owens had acted unreasonably in the litigation by filing the case without basis or merit. Courts don't like it when you're using them as a weapon for your own bullshit. And that is the kind of thing where the courts will come and start hammering you. So let's say I'm going to stop picking on Kurt. Let's say I'm going to, we're going to pick on Bob again. Bob. So let's say I don't like Bob. And I decide to file a lawsuit against Bob for, I don't know, defamation, assault, conversion, everything I can name. And my evidentiary basis is fuck all. I just made it up. And so Bob is like, I move to dismiss. And I'm like, I'm going to refile. And then, and I tie Bob up in expensive litigation. And it becomes clear that the only reason I'm doing it is because I don't like Bob. And I don't actually have any basis for it. Like, it's not that I don't like Bob because he did all these things. It's I don't like Bob. So I'm accusing him of a bunch of bullshit just to use the court to fuck with him. The court will be like, so, here's the thing. We're going to fuck back on Bob's behalf. And the court can absolutely cause you all sorts of damage on that. So, yes. Wasn't Gingras the lawyer who wanted the judge to force the other lawyer to have lunch with him? Yes. Gingras filed a motion to compel lunch.
Sounds great, man. I didn't know I could do that.
The court denied his motion to compel lunch.
I want lunch.
The funny thing is that somebody else filed a motion to compel lunch, which was actually granted by the court. And the court directed that one side would pay for the dinner and the other side would pay the tip. And they ended up going for lunch, and the lunch was like $80. And so they left an $80 tip. And, just because the one side wasn't going to be like, well, I'm going to pay less. They're like, no, we're and they actually, apparently, on that motion to compel lunch file, apparently they actually got along much better afterwards.
See, breaking bread helps, man.
It can. So, all right. What is it? Court
Can
may award
martinis be included in the lunch?
They actually specifically said it will not, that the one side pays for the meal price, excluding alcohol.
Aw.
Because otherwise you just go and you'd be like, break out the top shelf. They're paying for it. So, yeah. What is it? An applicant need not show both a financial disparity and an unreasonable opponent in order to qualify for consideration for an award. The reason why they note that is because a financial disparity is a substantial reason why they might do this, because what they don't want is a situation where an unreasonable but wealthy side is beating up on the poors. Because imagine, I've got the money to hire a lawyer. Like we're imagining that I have the money to hire a lawyer because I don't, but so I'm going to pay $100,000 in legal fees to hassle this homeless guy who obviously has no money to pay for a lawyer, right? They might be like, listen, you are, that's improper. But even more so than the homeless guy, let's say Bill Gates is pissed at me. Let's say Bill Gates sues me and then starts using all sorts of delaying tactics to really rack up the costs. And disclosure comes in and they disclose 1 million pages of material all printed. And I'm like, how the fuck do I pay my lawyer to go through 1 million pages of material? And they're like, tough shit. And, they start the costs become a huge issue. The court would be like, no, that's not cool. And so they might step in. The court also found it disingenuous at best, but certainly misleading to the court that Owens had testified the purpose of her motion seeking mediation was to inform Eckerd the pregnancy was not viable. You don't need mediation for that. You just send a letter or an email or something. It further found she had failed to comply with disclosure requirements, which caused Eckerd to incur substantial legal fees attempting to locate records that may or may not have existed, i.e. things like, was she ever pregnant? The court also concluded that the rules applied because Owens had provided false testimony as to the viability of the pregnancy and had sent Eckerd a letter prior to her deposition that indicated her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. That's a hell of a letter. I don't want to be sued for $1.4 million.
What collateral allegations?
I think she was going to suggest that he had SA'd her. And that was a new allegation. So, yeah. On appeal, Owens does not meaningfully challenge these findings, but instead argues the rules do not apply in paternity actions. So they permit a court to order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any proceeding under Chapter 3 or Chapter 4, Article 1 of this title. 3 governs dissolution of marriage, and relevant here, 4, Article 1 governs legal decision-making and parenting time. Owens argues that paternity actions are, by definition, excluded. A family court's authority to conduct legal decision-making and parenting time proceedings is provided by 25402. Under that statute, a parent is required to request such a determination in any proceeding for marital dissolution, legal separation, annulment, paternity, or modification of an earlier decree or judgment. Here, Owens petitioned the trial court for orders concerning paternity, legal decision-making, parenting time, and child support. While the court ultimately did not issue legal decision-making and parenting time orders, Eckerd defended any proceeding under Chapter 4, Article 1 of this title by virtue of her petition. It's like, you put those things at issue. You put those things at issue, so that is all on you. And we did not make the goal. We're going to start the goal again for for cracking open a Lucky. So there we go.
How about a goal to help Kurt pay his taxes?
Oh, are your taxes kicking your butt?
Well, yeah, this shadowy cartel recently stole like $5,300 from me. They go by the name IRS.
The lack of withholdings from YouTube is a thing.
Yeah.
Because then the government comes after you and they're like, so you owe us all the money? And it's like, how about some of the money? They're like, no, all the money.
Sucked it right out of my bank account. Lame.
So even assuming the trial court's fee award was improper under 25 through 24, because of this case's procedural posture, the court findings would have supported a fee award under 809. So Eckert cited 809 in seeking attorney's fees, so the issue was properly before the court. They're like, we could have given them the money under some other things, so that's fine. And permits a court to order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding.
I've been looking at nice watches recently. I could have bought a very nice watch for $5,300. I'm just saying.
Well, the government
there were some Grand Seikos I could have bought that would have been that much money.
The government is going to buy a nice watch, and you're going to pay for it. Kurt's got the sad face. So, yeah. We reject Owens' suggestion that this paternity action somehow transformed into some other type of proceeding because the parties only incurred fees after it was scheduled for administrative dismissal without prejudice. The court did not err in awarding attorney's fees. I love this. We reject the suggestion that it somehow transformed into some other type of proceeding. It's like, okay, yeah. Michael Gordon notes: 1, receive income. 2, calculate minimum possible tax owing. 3, set aside amount calculated in step 2.
I had the money. It still didn't make me enjoy paying it.
Also, YouTube income is kind of unpredictable. Sometimes you get more, sometimes you get less. And so it's like, how much are you going to make over the next year? I don't know. So, yeah. The trial court also properly awarded fees and costs under 415. So basically they're saying, there's all sorts of reasons why we can pay this. Now, they also note that they claim that the amount of the fee award was unreasonable. Substance of her argument is that below she had noted the amount of fees was patently unreasonable in light of the controlling standard of Ethical Rule 1.5. But she fails to identify with any particularity what evidence supports her argument. We conclude that the court did not abuse its discretion in fixing the amount of attorney's fees it awarded Eckert. That's a very brief paragraph that basically says, you had no argument. You said the amount is too much. You didn't say why it was too much. You didn't say how it was too much. You couldn't defend that shit at all. So, no. All right. We're going to skip ahead a little bit here just because, we'll get to the more interesting parts. Judicial bias argues that the trial...
This should be good.
So they argue that the trial court improperly performed an independent and undisclosed investigation into the facts of the case, and from this investigation made post-trial findings not based on the evidence admitted at trial. In the findings of fact section of its ruling, the court stated that Eckert's expert had testified that Planned Parenthood is not open on Sundays, when Owens testified she sought care July 2nd, 2023, a Sunday. The parties agree the expert did not testify that Planned Parenthood is closed on Sundays. They reviewed the transcript, and that the court's finding was therefore erroneous. Instead, they dispute which standard of review should apply. Standard of review is everything. Owens argues that this amounted to structural error requiring automatic reversal because it proves the trial judge was biased as shown by the judge's decision to engage in unlawful conduct.
Get bent.
Which violated the process. Conversely, Eckert argues that the controlling standard for alleged mistakes in family law proceedings is harmless error. I mean, how do you show that they actually conducted some out-of-court thing and they didn't just assume that they're closed on Sundays, right? So structural error is generally applied in criminal cases and is error that affects the framework within which the trial proceeds, rather than simply an error in the trial process itself. Supreme Court has defined relatively few instances in which we should regard error as structural, but one of those instances is a biased trial judge. We nevertheless decline to apply a structural error analysis given the record before us. What would a biased trial judge be? Well, let's say
Judge Beverly Cannoni?
I wasn't going to name a specific judge.
Oh, sorry. I just knew the answer.
Let's say I decide to sue Bob, and the judge turns out to be Bob's mom. And sure enough, Bob's mom as judge is ruling against me on everything. Like, I just can't get a break. Every motion in limine shot down in flames. Every, objection, nope. And it's like, yeah. So that would be, bias. But they're saying that there's bias because of independent research. Well, what is their basis for that? Well, nothing. So here Owens moved for a change of judge for cause under the rules on the basis of bias and prejudice within the meaning of rules. The presiding judge denied her motion. While acknowledging that the trial judge's finding about Planned Parenthood's business hours was clearly erroneous, the presiding judge concluded that Owens had failed to show by a preponderance of the evidence that this finding reflected bias or prejudice against her. And they basically found that there was no evidence of external research. Owens contends we need not separately decide where the presiding judge erred when she denied the notice of change of judge for cause, because the requested relief is subsumed within the structural error arguments that we must review de novo. But as we explained below, the record does not show that the trial judge was biased. Thus, even assuming without deciding that structural error applies in family cases, it did not occur, and the presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. He basically said they did a bunch of extra research, and it's like, how do you know that? Well, because they must have. And he said the judge was clearly like watching these influencers. How do you know that? Well, because that would be really convenient for my case, Judge. Owens argues the trial court's erroneous finding of fact demonstrated it was biased, therefore committed structural error. This argument is based on conjecture. She does not provide any evidence showing actual bias. Her claim of bias is based on her assertion that the court intentionally tried to conceal its misconduct in performing its own post-trial investigation into the facts by falsely attributing the testimony to Eckerd's expert. Which, wouldn't it just make sense that you would actually think that, like, they just got it wrong? Owens claims that this is the only plausible conclusion, given that online supporters of Eckerd had vociferously posted about this issue online hours after the trial ended. These unsupported and speculative allegations fail to meet her burden to prove bias by a preponderance of evidence. It's like people posted about it online, so she must have looked there, right? Aurora says $5 for Kurt or for Ian and $5 to Kurt on Ko-Fi coffee. Yeah, love this collab. My two favorite Firearms guys. There we go. I just wanted to make sure you saw that, Kurt.
Aw, thanks.
Owens further contends that any independent factual investigation by a trial judge is unlawful and shows bias. But for structural error review to apply, the type of judicial bias that must be shown is that which implicates a party's due process rights, such as bias based on a direct, personal, substantial pecuniary interest. None of those grounds apply here. We therefore review for an abuse of discretion. And the thing is we don't even know where this information came from, right? While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias apart from any structural error claim, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. Owens correctly notes that the court misstated trial testimony. But she's incorrect in asserting that because harmless error analysis does not apply, she does not need to make a separate showing of resulting prejudice. Prejudice will not be presumed, but must be evidenced from the record. Therefore, even if the court conducted independent research under a prejudice analysis, we would still have to determine whether Planned Parenthood's business hours were vitally important to the court's ultimate conclusions, as Owen claims. However, Owens does not argue prejudice. Consequently, the presiding judge did not err, and they lose. So, attorney's fees on appeal. They request that their attorney's fees on both sides request their attorney's fees and costs on appeal. Eckert additionally requests fees and costs under 25 through 24. Under both statutes, the court may award attorney's fees and costs after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings. While the record does not support a disparity in the parties' financial resources, Owens' position on appeal is unreasonable. Yeah. Her Rule 26 argument is not grounded in law or fact. Likewise, her assertion that the trial judge was biased and committed structural error does not meaningfully address the trial court's rulings below and also ignores the applicable jurisprudence. We therefore award Eckert his reasonable attorney's fees and costs on appeal upon his compliance with Rule 21. So, Kurt.
Yeah.
How would you feel about that decision there? If that was about you.
Don't feel good, man. Feels like I'm paying $150,000. Feels like I'm paying.
I'm guessing it's probably more like $190,000 after they consider the appeal issue.
Mm-hmm.
I saw somebody say $40,000. $40,000 doesn't sound like a bad number to me for an appeal. And apparently they are really adding on to this because he's filed a motion for reconsideration and has said he wants to go to the Supreme Court.
Good luck. On what issue?
On the issue of the
Supreme Court has better things to do with their time.
I think they do. I see people saying Bobberly Canone or Canone. Oh, yeah. Well, and this is a good question. Do you think she'll actually pay it? It's not like they can garnish her wages since she doesn't actually work. If she has... Oh,
I'm going to get a writ of attachment. I'm going to take her stuff. I'm going to send the sheriff into her house. I'm going to take her hand towels. It's going to be great.
This is the thing, is it's actually really shitty to owe money because usually there are limits on what kind of things can be taken. And those limits are usually pretty minimal. So usually those limits are things like, often you can't take a worker's tools. So if somebody's a carpenter, you might not be able to take the tools there. If somebody is, and there's usually things like, now this depends, but I see people saying she owns property. It sounds like that's actually her parents' property. So she may not have it. But the thing is you're always going to own a certain amount of stuff. And if you really want to jerk somebody around when they owe you money, you can do it. So let's consider the Alberta case. Let's consider that, I sue my neighbor and I get a judgment of $500,000. Well, the neighbor turns out is renting. And so he doesn't actually own the land. But I can go and I can bring the neighbor in for questioning every so often. And I can be like, neighbor, you are now under oath. I am going to force you to testify as to what things you own. And so that's an unpleasant thing. But you can bring them in on a regular basis to be like, so you still own nothing? And the other fun thing you can often do is you can then get orders that allow you to go in with sheriffs or deputies or whatever the enforcement is and go into wherever they live And with the exception of exempt property, you can start taking shit. And the exemptions are often very specific. And so they'll say things like, I cannot take the tools of the trade. And I'll be like, well, they're a carpenter. So I'm going to go and I can't take the hammer or the saw or anything else, but I'll take your blender. I will take your that picture of you as a child. I will take that childhood photo. We're taking that and we're going to sell it at auction. That, we're going to take a picture, your granddad died. We're going to take that picture too. We're going to take,
take the urn.
Yeah, we'll take the urn. Sometimes it's literally down to things like, the law might say, and like 6 sets of clothing. And you might go in and you're like, so, pick 6 sets of clothing. And I'm taking everything else. And so you're like walking out with their underwear. You're walking out with their shoes. You're walking out with all the stuff, right? And, that's the thing. If you've got the other side that really wants to go after you, they can make it suck. Now, typically, people who you owe money to don't care to do that. Like, let's say Kurt sues me over a business thing, right? Kurt probably
all this defamation you've been doing to me today, for example.
Nobody takes it as a serious statement, but yes. So, you'd be sitting there, you'd probably be like, I'm going to take any real property you have. I'll garnish your wages, I'll whatever. But
I'm taking the stick with all the Sharpie glass on it.
You'll take the ouchie stick.
Yeah.
The ouchie stick. But you probably wouldn't be like, you probably wouldn't care enough to come in and be like, so I'm going to count out how many sets of underwear you get to keep, right? Maybe you might be that petty. The bank, if I owe the bank money, the bank isn't coming in to take my underwear, right? But if you piss somebody off in a suit like this, they may use every measure that you've got. The other fun thing about owing people money,
yeah.
I don't think we're at the goal, but I'm cracking open the lucky anyway because we're at 4 out of 10.
Can I tell a story relating to this? I've told this before on my channel.
Oh, absolutely.
So
Go ahead.
it's one of the few cases I've actually worked in court because my main job wasn't in court. So it's one of the few cases I worked in court. I was representing a woman in DC on a pro bono basis because DC has some special pro bono rules. So even though I wasn't licensed there, I was allowed to work the case, which is a whole nother set of stories. But anyway, so I was representing this woman in a case. She owed money in a landlord tenant. She was the tenant. And I thought she had a pretty good defense, but then she testified and she blew the entire case apart, which, happens. So we get to the end of the case, right? And we're coming back tomorrow for like basically a decision. And I said to her, I'm like, let me tell you what's going to happen. We're going to lose tomorrow. And as soon as that happens, the other side is going to stand up and say, we want a writ of attachment. Now, my client had some nice stuff. She fancied herself to be a musician. So she had like a really nice keyboard. She had like really nice speakers. She had some really reasonably expensive stuff in this shithole apartment. I was like, what I need you to do is I need you to go home tonight and I need you to clear out your apartment tonight. And I need you to come back to court to me tomorrow. And I need you to give me the keys. And she said, okay. And she came back the next day and I said, did you do everything I said? I said, I sure did. I'm like, fantastic. So fast forward like 2 hours later, we're sitting in court, right? And the judge says, I rule against your client, unsurprisingly. What happened? The other side, without breaking half a second, the other side says, you said, Your Honor, we moved for writ of attachment. We want to get all the things. And Your Honor, and I just stood up and said, Your Honor, the motion is moot. The apartment is empty. Here are the keys. And they were so sad. And I was so smug. It was great.
See, I have the opposite. There's a landlord where I was representing the tenant, and I one, and the landlord is being a giant douche. And so it might be possible, it might be easy to get, he doesn't want to pay the money. So it might be easy to get the money back by just like forcing the sale of one of his properties. That's one of the most reliable ways to get the money. But you don't have to do that. You can actually proceed however you want in order to collect the money. It's your discretion. And so it might be worthwhile to go and, like, hey, let's take your family photos and sell those, because if you're not going to pay us, then yeah. Now, I should note, this is a person who very much deserves the absolute shittiest the world can possibly give him. But yeah. I guess the other fun thing is I see somebody saying attach the rents from his other properties, just like, we're going to take those rents as payment. We're not going to force the sale of the property. We're just going to force you to force the sale. I see somebody saying, never heard of a douchey landlord before. The thing is, I've noted my dream of doing pro bono law, and I currently do like criminal and firearm. But the one area of law I would love to do, if I could, would be, if I was doing it for free, I would do stuff in landlord-tenant, specifically tenant side. And the reason why is because tenants never have any money in order to defend themselves. And so tenants get fucked by landlords all the time, sometimes literally. But, they'll do things like, oh, yeah, they'll do things like saying, oh, well, I'm going to keep the entire security deposit. And it's like, well, why? Well, because there's like a scratch. And somebody says no pro bono for landlords, because landlords have the money to hire people. They could, if they need to, they could borrow off the land to do that. But the number, like, when I was renting, every time I moved out of a place, miraculously, there was exactly as much damage, they say, as the security deposit. Right up until I fight it. And then I'm like, prove that damage is there. And they're like, well, the oven wasn't sufficiently cleaned, and that's worth like $1,000. It's like, no, we cleaned that oven. Here's the pictures of a perfectly clean oven. And so they love to play those games. They love to do all of that stuff. And I would just love to take those guys on for sport. So yeah. Now I'm just looking at other options because we got a little more time. I don't really feel like looking at the Baldoni versus Lively stuff because I am so far behind on that. And if I jump into a midway thing, it is going to sort of suck. So instead, how about we watch some Firearm Expert?
Okay.
You down for Firearm Expert?
Sure.
All right. I'm going to switch it
Are
over.
we watching the judge? Are we doing the judge thing or the Ninth Circuit thing? Have you seen this?
Oh, I saw the Ninth Circuit one where the judge pulls out the...
Yeah. Have you ever done a reaction to that yet?
I did. The thing is I agree with the judge's contentions about the guns.
Mm-hmm. Were you contradicting the judge on firearm points?
No, the judge was right on the gun points. The problem is just that the judge was also wrong to do it, if that makes sense. Because the judge should not have done his own analysis, and he imperils the thing. So,
oh, you're no fun.
I know I'm no fun, but here's...
All right,
this is Lori Vallow. Oh, yes, AI lawyer. We still got to talk about AI lawyer. We'll talk to AI lawyer after this. Lori Vallow is defending herself. So
she's doing a better job than I expected.
She is, but she's not doing a good job.
I've seen lawyers do worse.
That's fair. Oh, I'm being asked to do a swoop. So first we can have a look at this guy's face and his facial expression. And I hate it. So I hate his face. Swoop. Look at this. Look at his face. Now, somebody, I'm just going to say, I find it a little hard to take a guy like this seriously when it's like, okay, you're supposed to be an expert, but you chose that facial hair.
Mm.
It's like, okay. He actually doesn't do too badly. All right. When's he going to start talking? How much?
Please introduce yourself to
There
the
we
Turn
go.
up the
jury.
volume,
Good afternoon, everyone. My name is
All right. We got to turn up the volume.
please.
Yeah, we can do that.
I'm hearing myself again.
Yeah, that's going to be the case in order to pipe this through.
Jeff Moberg. I'm a forensic scientist with the Arizona Department of Public Safety in the Firearms and Toolmark Unit.
How long have you worked there?
I've been with DPS since February of 2013. I've been assigned to the Firearms Unit since October 1st of 2018.
And I've chosen facial hair that makes my chin look like a ball sack. A very particularly hairy one, but yeah.
Can you tell us about your education and training to work in the area of firearms identification?
Sure. Part of the hiring standards for the DPS Crime Lab is I do have a bachelor's degree in chemistry from Arizona State University. My specialized firearms training is I attended the National Firearms Examiner Academy hosted by the ATF in Laurel, Maryland. The academy consists of 4 phases. It's approximately a year long, with phase 1 being research and history of and all of the techniques that go into it. Phase 2 is a full on-site 17-week training experience in Maryland, practicing exactly what it is that we do. Then we go into practical examinations, meaning I'm doing competency tests and proficiency tests throughout the summer and preparing a research project, which in phase 4 I will present and conduct mock trials.
Do you have ongoing training as well?
We do. Every year we're offered the opportunity to attend SHOT Show, which is the firearms industry trade show in Las Vegas.
SHOT Show is a lot of fun.
I've never been. I had the opportunity to go once. I didn't go, and I should have.
Ah, sad face. I
Yeah.
will try to bring you along.
Runkle promised he's going to bring me.
Fine. I will try to make it happen. But yeah, he goes to SHOT Show, which means that there is a possibility that when I'm at a SHOT Show, he might be like, "You're that asshole who had thoughts about my beard," and I'm going to be like, "Yeah,
Yes.
the thought is shave it."
Every year, there's also the Association of Firearms and Toolmark Examiners meeting once a year, which is our annual training. It is nothing but peers within my discipline doing seminars and presenting on findings for various cases and various new technologies coming out.
And in DPS itself, is there any type of QAS or
Now, I'm a massive geek, so whenever they say DPS, I'm thinking damage per second. And I'm like, okay. Now, somebody, like, if this guy was my expert, I would absolutely tell him, like, hey, this thing you do with your face, you need to not have that facial expression, because if I'm the jury, I hate it. Yeah.
means to ensure that all of the firearms examiners are continuing to perform appropriately?
Absolutely. After the training, we are all given a competency test. We have to demonstrate our ability to do the job. So it's a very complex test consisting of all of the disciplines that we do, toolmarks, firearms, serial number restoration, various other aspects of my job. But then every year we're giving a proficiency test from an outside source, so we're testing we're demonstrating our continued competency within the field.
So I want to start by asking you just some generic questions about how a semi-automatic handgun works.
So he's actually going to do a pretty decent job of explaining this.
So a semi-automatic gun, meaning a semi-automatic means that it is designed to fire one round with a single pull of the trigger, but it's also meant to cycle the firearm. And what I mean by cycle is the process of loading a firearm means introducing a magazine, particularly in a semi-automatic, which contains a number of cartridges. Cycling it means pulling the slide back and allowing it to go forward. When that happens, it strips off one of the cartridges from the magazine and loads it into chamber. So we call that chambering. At that point, it is ready to fire. When the trigger is pulled, the firing pin is released on a striker type system. It's a spring-loaded firing pin, or a hammer type system where it's a weighted hammer that goes in and strikes firing pins. You hit this back of this cartridge to ignite the round. It then begins, the pressure builds up within that cartridge, expels the bullet down the barrel, but that same amount of pressure is also working to push it back. So it pushes that slide rearward. So it starts to move it back, unlocks the barrel, lets it go all the way back, and then it comes forward and loads the next one.
It's actually a pretty good description.
So,
Yeah.
trying to pick up. First, I have Exhibit 76 here. Is this a semi-automatic handgun?
Yes, it is.
And then I'm going to put 85 in here.
So they've got the,
Semi-automatic handgun.
you can also see that it's got a threaded barrel. So threaded barrel for a suppressor. Now it's got a protective cap on it, so you know it's not going to get damaged. But I'm like, all right, neat. Doesn't look like a bad gun.
Yes, it is.
And then I'm going to put 85 in here. Is that what a live round looks like?
A live round, or we call it a cartridge. It's just a single.
I don't think it is, because he doesn't actually like. Otherwise, that facial expression would be more of a common thing, and it's only something that he does, and he appears to do it volitionally. So I don't think it's that, but fair enough.
Unit of ammunition consists of the cartridge case, primer, powder, and projectile.
So when a handgun,
I'm trying to identify the gun. I see somebody says it might be a P320, in which case I don't think it's a P320, because otherwise we would expect it to be going off accidentally right now.
gun is used and the trigger is pulled, we have a
Or with a
projectile that goes out to
P320, when the
barrel of
trigger's
gun.
not pulled.
What happens to the rest of that cartridge or live round?
I mean, if it's a P320 and she's not running a defense of this thing went off by accident, then she doesn't know what she's doing.
So the rectangular portion on top, the black portion of the slide that's on top, that whole thing moves. So it will actually, when the cartridge is fired, the pressure of that cartridge will force that rearward, and it opens up that chamber so that the expelled cartridge can be ejected, the cartridge case will be ejected, and the new one can be loaded in via the magazine. The very bottom here, where the kind of the hand is grabbing at the bottom, is where the magazine is inserted.
So, Exhibit 77, is this where you're talking about where the cartridge is going to eject from?
That is actually showing the side of the barrel, that which houses the chamber, but that section opens up, and that is where the ejection takes place.
So you had talked about this in
I
some of
see
the
somebody
different
saying
jobs that you
Springfield
do as a
XDM,
firearms analyst. When a person fires a semi-automatic handgun, are there any sort of identifying tool marks that might be left on the projectile or the bullet?
Absolutely. All of that pressure that builds up and is pushing the cartridge case back, it is resting against what we call the breech face. The breech face has a hole in it where the firing pin comes through and it strikes the primer. Primer is just that little button in the center of the cartridge. It's actually a very volatile compound that ignites the powder charge instantly. So all of that pressure
Not quite
builds up and
instantly, but
presses
yeah.
against that breech face. This being a semi-automatic, as it cycles back, the barrel has to unlock. So it moves slightly back, but then as it unlocks, it drops down. And as it drops down, that cartridge case is scratching up against the surface of that breech face, imparting all kinds of marks that we use for comparison purposes.
When the projectile itself is fired out the barrel, are there any tool marks left on that?
Yes. So when the bullet is being pushed out of the barrel, through the barrel. All of that pressure is pushing it through. A barrel is rifled. Now, rifling is a pattern of lands and grooves that are in a rotational pattern that impart the spin on there.
All right, so let's talk about lands and grooves. So
Hills and valleys, baby.
yeah, that's basically it. Hills and valleys is a good way to put it. The inside of the barrel has essentially a spiral pattern in it, and what that's for is to make the bullet spin as it flies. So, if you're imagining your bullet, it is rotating. Why do they do that? Well, the same reason why I am told you try to spin a football when you throw it. I am not the sort of person who throws footballs, but I am told that is an apt comparison. What it does is it helps stabilize the actual bullet such that as it flies in a more stable pattern. It doesn't, yaw, it doesn't, whatever. And so, but in order to do that, you have those hills and valleys that it pushes through and that force it into that spin. So that's what they're talking about there. Now, he's going to talk about like the number of lands and grooves because that can vary. So can the twist, which is how fast that sort of spiral goes. So those
and
things
which way it twists, because some go one way and some go the other way.
Yep, that is true.
That pressure causes the back end of that projectile to expand and to fill that void. So as it's going through, it's dragging along the inside of the barrel, picking up any of the imperfections from the manufacturing process that are there, similar to a fingerprint. So when it comes out, we're able to look around there and you can see
really a
the
fingerprint.
pattern of the rifle all the way around the bullet and the individual striations or scratches on the surface coming from the inside of the barrel.
So if you are provided with a gun, casings, and projectiles, are you able to determine in any way if those casings or projectiles were fired from a specific gun?
Yes, and we do that by doing what we call a comparison. So we go ahead and we take that fired evidence and we're going to look at it. We want to verify that there's markings on there that we can use for comparisons.
So here's the problem. I think that they're probably in good shape when they're doing exclusions, i.e. these two things cannot be fired from the same thing. But when they say these two things are a match, they don't actually know how matchy they are. The example I give is like your house key. You can very much tell if your house key doesn't match a particular door. But that doesn't necessarily mean that if it turns in a particular door, that this excludes all other doors on the planet, that this key and this lock were necessarily made for each other. And the really specific example I give here is that when I was a kid, my parents had a divorce and it was not amicable. They did not like each other. And by pure stupid chance, the door key for mom's house and the door key for dad's house were cut to the same pinning. And so by stupid random chance, without anybody doing anything to try to make it happen, those two keys work together. Now, when my mom found out that that dad's key also worked in her house, that got changed really fast because, but the thing is if you have a house key, you don't know how, just because you found a key that works in a particular lock, you don't know if that's the only lock that it works into. It might work into, in all sorts of places. And so that notion that they can match for certain is not clear. So, yeah.
Yeah, also, it might become more clear with more use. So if you imagine that you had the same key, Quickset or something, and every key that was cut the same way, they would all be essentially the same at the start. But as that key is used more and more in the same in that same lock, it will pick up patterns over time. So as the key is used more, it can become more identifiable. This is also true with firearms. When they're factory new, there's going to be less distinguishing marks. One thing off the line is going to look basically the same as another thing off the line. If you use a firearm a lot, then over time, it might pick up imperfections that allow it to be more unique, but he's not making that clear.
Yeah. And I mean, the problem is the whole idea is basically that when one tool, strikes another, like if you
Yep.
have, this screwdriver going up against a surface, that both things mark each other. But the issue on that is, well, you've got a factory that's knocking out barrels. And so it's knocking out barrels. And let's say they put out 1,000 barrels that day. Well, how much does barrel number 612
Yep.
go to 613?
Yep.
Michael says, honestly, Runkle, you believe that? Isn't it more likely your dad just had the keys for his new place the same as the old place? No, because it wasn't the first house we moved into. It was the second house that Dad moved into. So it wasn't like he specifically had it rekeyed. It was literally the keys were handed to him from this other place. So I don't think he like specifically had them cut to match or anything like that. But let's imagine, so if you've got like 665 versus 664 off this thing, how much are they going to distinguish each other? Similarly with the locks, let's imagine that you got a locksmith who's just a lazy bastard. And so instead of cutting each lock that he makes uniquely, he just pins them all the same. And he's like, no one's gonna notice. Well,
Yeah.
that's an issue. So yeah. All right, carrying on here.
Then I'm going to go ahead. I'm going to test fire this firearm. I'm going to collect those test fired cartridge cases and projectiles if need be. And I'm going to do a comparison side by side on my comparison microscope. It's just a high powered microscope that allows me to see two things simultaneously side by side at the same magnification. So I'm going to have them side by side and try to line up those scratches and marks that are left on there from the machining process to the next.
So what is the key thing to take away from this? How does he make that comparison? Well, he makes that comparison using his eyeballs and using his discretion. And the problem is that these guys are given a bullet and a gun to match it to, and they're told, we really need these things to match.
Mm-hmm.
And so it's not a blinded test. This is a big problem because it's not blinded.
So when we're talking about a barrel, you said there's like lands and grooves in there. Is that alone enough for you to identify if a projectile was fired from a specific gun? Or are you looking for more specific, unique characteristics from each gun?
So each one, we start with what we call class characteristics. The class characteristics are those that are pre-designed before manufacture, such as what caliber is it? Is it a 9mm? Is it a 45, 40, whatever it may be? Then we're going to look at how many lands and grooves are there. If there is, maybe there's 5, maybe there's 6, maybe there's 8. All of that we use as an initial screening. Can this come from this gun? Say I have a gun that's a 9mm and I have a 45 bullet. That's not possible. So
these are like really broad characteristics. Let's say you want to determine if that dog or if that animal you're looking down the street is your dog, right? Is that my dog down there?
Mm-hmm.
You hear noises and you're like, is it my dog that, maybe you're looking for your dog. You see an animal and it's like, if that animal happens to be like, a hippo, you're going to be like, that clearly can't be my dog. If that animal has, horns, you're like, it's clearly not my dog. But then once you get it down to dog, you're starting to look at like the specific, like, does it have the right fur pattern? Does it have the right shape? How did my mom find out about a key? I figured it out because I used my dad's key and then I opened mom's door and I was like, wait a minute, that shouldn't have worked. That was the wrong key. And then I told mom and mom went, oh, we're changing that immediately. So, yeah.
It's an automatic rule out. But those imperfections from the manufacturing process are what we use, and how the scratches translate into there are very unique to those barrels.
So you said you test fire the weapon.
Unique is like, no,
why
we
do you
don't
do
know that.
What are you using?
Also, something can't be very unique, strictly speaking.
So when a case like that comes,
It's either unique or it's not.
Right,
Yeah,
exactly.
yeah, for sure.
then whenever we receive a weapon, we first and foremost, we want to verify, number one, that it's safe and unloaded. Number two, that it's actually operational as a weapon. So we're verifying that it can fire and it works as designed. But then I'm also using that time, I document the condition of it as I received it. I document any of the features.
This was not so much of an issue in this trial as it was an issue in the Rust trial. Rust was all about the how did you document that it was in firing condition and properly functioning when you got it. So
that are on there, such as in this particular case up here, we have a brown and black gun. That's one of the notes that I would have on there.
When you are doing this comparison and looking for these unique characteristics that you may see from the tools
and
or
of course
the actual
the
combustion of
lawyers
this,
latched on.
are there different levels of interpretation or conclusions that you're able to reach during this comparison process?
Yes, when we're doing a comparison, we're first and foremost looking for marks that recreate. So the different levels of opinion that I can form at the end is I can identify. I can say this piece of fired evidence was fired from this gun. I could say this.
This is the thing. That is the one conclusion that I would love to eliminate from, from that, because you can't know necessarily. And I want to make a test to prove that, but
this piece of evidence was not fired from this piece of gun, or this particular gun, excuse me. Or if there's just none of those marks that are reproducing or an insufficient amount of marks for us to actually compare, we can actually go out inconclusive, meaning I'm not sure whether it was or not.
So I'm going to have my paralegal go up to you with a few items here. It is exhibits 235, 38, 40, 239, and 246.
let's just, when we get down to the fact that they're doing this with their eyeballs, let's sort of consider the, let's say you got a picture of two people, right? Or two pictures of people, rather. And you're trying to determine if it's the same person.
Mm-hmm.
Now, you gotta say, there are probably circumstances where you can say, I don't know, right? Or there's definitely going to be circumstances where you can say, I don't know if these are the same person. There might be circumstances where you can say, these are definitely not the same person. Like one of them is like a white-haired elf-looking guy, and the other one is like, some black guy with, red hair, right? And you might be like, okay, those are not the same person. But to get to conclusive that they are the same person is a lot harder. And they say that they can do this perfectly. But the thing is like people, we don't make people out of the same machine. But if we did make people in a factory, then theoretically there'd be a person before, if that makes sense. So, yeah.
I'm not sure where you were going with that one. I was just letting it roll.
Fair.
I keep those. I can start with 2.
But you can't know there's not an identical twin or somebody who looks.
Were
just
you
like
provided
you.
with that gun as part of a request to determine if you could? Well, were you provided with that gun?
I was. When we receive evidence such as a firearm, we actually initial, date, and put the identifying information to the case on the firearm. Right here, just underneath the slide on the frame of this firearm is the DR number, our department record number, the item number. So the combination of that DR number and the item number is our unique identifier to track that piece of evidence. And then my initials and date.
Were you provided with a couple of casings, 238 and 240?
Yes, I was. And again, when I received these, when we receive evidence such as this fired casing here, which is 240, we initial and date the day we receive it. So it's here. There's my initials and date from when I resealed it. It's currently hiding up. It's actually right up here at the top where I initial and dated it when I received it.
Okay. And were you also provided with a projectile, if you can look at 235 and 239? And I believe you only had one of those.
That's correct. There's the one bullet I received right underneath our unique tracking. We barcode everything. It's got our department record number, item number. I initial and dated it as I received it.
And which number was that?
This is item 239.
Thank you.
By the way, you will note a distinct difference between how they handle their evidence and how the
Yeah, I was doing this the other day when I was talking about the Texas high school stabbing case and going through a police report. It's like, who told these guys about crime scene log technology? Who told these guys about taking photographs of the murder weapon before it was moved?
Oh
You know?
man. That one I'm waiting to talk about because apparently there's video, and right now everybody's super like people have decided either it's self-defense or
Yeah, I've
it's
talked about it multiple times on my channel, and people are pissed at me, even though I didn't say the things they think I'm saying, which is really annoying.
I look at that one and I'm like, it could be self-defense or it could be completely not self-defense, and I don't know, but I want to see this freaking video because apparently this confrontation was recorded. So
Although I did learn something the other day, which I shocked. I had to look it up. Apparently, knives under 5.5 inches are legal for students to have at school, which in Texas, who knew? But yeah,
interesting.
You can carry a pocket knife at a school. Okay, that's cool, I guess.
I mean, you never know when you might have to.
It's Texas, I guess.
Texas is like, you can carry a handgun so long as the barrel is 3 inches or less.
What were you asked to do with these items?
This particular case, I was asked to compare the cartridge cases and the bullet back to the firearm.
And that's the firearm that we see here in Exhibit 77. What we see is 246.
Yes, it is.
All right.
That's
So starting with this,
super
what,
useful. So
what can you tell us about the gun
I
itself?
would
What is
totally
the
use that.
caliber? What is the brand of that?
The firearm is a Springfield Armory XDM 45 caliber.
Holla. I like Springfield Armory.
And
Yeah, they're pretty good.
When we talk about 45 caliber, what does that mean?
45 refers to just the size of the bore. In this particular case, it's a 45 auto caliber, so or 45 ACP, common to most.
45 ACP is different than the 45 long Colt that you will have seen in the Rust trial.
Also different than 45 gap, if you can find someone who uses that.
I don't know anybody who uses 45 gap. 45 ACP is pretty common, and it's stubbier than 45 long Colt. So
45s made today. That's actually the measurement of the bore.
Were you able to, when you looked at you told us you often look to see just.
yeah, I don't think it's a stroke or anything because he's not having that issue at the moment, but I could be wrong, and I take the point.
Initially, did these all match together? When you looked at the caliber of those casings that you were given, did they match with the 45 caliber?
The two cartridge cases I received were Fiocchi brand 45 auto caliber cartridge casings.
Okay. Now, what about the projectile, the bullet that you're given? Is there a way for you to determine if that is consistent with a 45 caliber?
I like the Fiocchi people, but they were not interested in sponsoring Runkle of the Bailey. When I asked them if they would be interested in doing an ammo sponsorship, they were like, oh, and I'm like, oh, I'm Canadian. They're like, yeah, go F yourself. So
Fired from a 45 caliber handgun?
Yes. So when we receive a bullet like this, I'm going to go ahead and measure the diameter across the fired bullet to achieve that. And it measured, I don't know the exact number, but it's approximately 0.45 inches.
Okay.
Now, the thing is you can get different degrees of deformation and it depends on what you've hit and depends on your bullet. Because if you're using like a simple lead bullet and it hits something, hard, it might, for instance, flatten out. So, and if it's a hollow point, it may expand. It's all of those things.
Now, when you first were handed the gun, you said you'd make some notes about that. Did you note anything about it as to whether or not the gun appeared to have been previously fired at some point?
The only notes that we take is we do look down the barrel of the gun. What I'm looking for is mainly safety purposes. I want to make sure there's no obstruction, because if I fire it and there's an obstruction, could be catastrophic failure of the firearm. But I'm also looking at and documenting the rifling. And when we look down a barrel, we can see, I would notate that it's slightly fouled barrel or whatnot, meaning that there's powder.
So you've probably heard you got to clean guns. And when you fire a gun, the powder burns, but the powder doesn't burn perfectly. It leaves crap in your gun. And so what he's saying is you can look down the barrel, and if it's not been cleaned, you're not going to see perfect, shiny, smooth metal. You're going to see crap. And I wish I could show you, like, if I could pull out a firearm, I'd be like, hey, this is a clean barrel. This is a dirty barrel. But I can't, because YouTube. And also people would be like, why are you pointing a gun right at us? And I'd be like, it's just the camera, folks. But yeah.
Particles and or traces of bullets going through the firearm.
So that would mean it was consistent with having been fired at least.
Correct.
You'll have both powder fouling and lead fouling. And lead fouling is much more of a pain in the ass to clean out.
So you talked about test firing. Did you test fire this gun?
I did. I test fired this particular firearm into a water tank. I used the water tank because we wanted to collect projectiles for comparison purposes, and the water tank allows us to do that without damaging the bullets.
What kind of ammunition do you use? How do you determine that?
So first and foremost, we would like to use like ammunition. So this was Fiocchi brand ammunition. We hopefully would have some of that in our reference collection. However, I did not, so I would grab the next closest type of ammunition. I believe it was Winchester that I used in this particular case that has the same exact type of primer, the same exact type of casing, and the same exact type of projectile.
What they'll often do, if they can, is like, let's say they came in and for some reason they were seizing a bunch of my guns. They might take my ammunition and use it. Now, I don't know why this guy doesn't just go to the gun store and buy some, because it's not hard to pick up Fiocchi ammunition, but they just pulled Winchester. Okay.
When you talk about the same exact type, are you talking about like the metals or what are you talking about?
For instance, the bullet in this case is a copper jacketed round nose full metal jacket. So I would look to test fire a copper jacketed full round nose bullet.
Okay. So when you test fired this gun, did you know anything with regards to the functionality of it?
I noted that it functioned as designed. I did test fire this by hand chambering. I didn't try a magazine in there because one wasn't submitted with it, but it operated with no problems.
Okay. How
Gun
many
went
times did
bang.
you test fire it?
We collect a minimum of 3. In this particular case, I only did fire it 3 times. That's all that I needed.
And so each time you're having to put a bullet in there and pull the trigger each time.
That's correct.
If you'd had a magazine, would you still have had to pull the trigger each time to fire it?
Yes, it operates still semi-automatic, so the trigger would have to be pulled each time to fire a cartridge case. I just wouldn't have to reload one into the chamber each time.
So once you created these test fire, let's start with cartridges, did you attempt to compare those to the ones you were provided, exhibits 238 and 240?
So one of the first things I'm going to do is I'm going to collect my test fires and I'm going to compare them to each other. And why I'm doing that is I want to make sure that there's marks on there that reproduce over our test fires. If there's no marks reproducing, how would I be able to compare it to the evidence? From there, once I determine that it's a sufficient.
Now, that's not normally going to be a problem, but it could be a problem if you're using things like, sometimes you see like a barrel that's done like, a printed barrel or something like that. Now, he is comparing rounds that would have gone through a magazine to rounds that didn't. So that's instantly a point of difference that you'll see on the casing, because you're going to get normally marks from the feed lips of the magazine. As it feeds off, those will scratch down. So that's a distinction that you won't see.
And I do photo document all of my comparisons. Once I figure it's sufficient for an identification there, I'll go ahead and do a comparison to the unknown evidence and make my opinion based on that comparison.
So the test fires that you have, you look to make sure that those are creating each time the same, both class characteristics and individual characteristics.
Correct, yes.
And the class being sort of the generic ones that every type of Springfield might create.
Correct, yes.
And these individual ones are characteristics that are specific and unique to this weapon.
Correct. They're from use, abuse, cleaning, anything like that, and the individual manufacturing of each component.
When you compared those two cartridge casings, 238 and 240, to the test fires that you created from Exhibit 246, the handgun, were you able to reach any conclusions?
I was.
And what was your conclusion?
I was able to determine
That you should shave. I'm sorry.
I identified those cartridge cases as having been fired on that particular firearm based on my comparison of the test fires to that evidence.
So the two cartridge casings, 238 and 240, were fired from the handgun you have up there, 246.
Correct.
You also, when you test fired the gun, did you collect the projectiles, the bullets?
Now, based on the Delphi case, I just want them to ask, like, would you ever compare fired cases, like fired rounds to unfired rounds? and just to see. But they're not going to ask him that because it's not.
I did.
relevant
I
here.
collected three bullets from our water tank for comparison purposes.
Did you go through the same process of looking at those three to see if they matched up?
I did, yes.
And did they?
They absolutely did, yes.
So again, they had sufficient class characteristics and individual characteristics for you to then proceed to try to identify them or compare them to the unknown bullet.
That's correct.
When you compared Exhibit 239, the projectile that was recovered.
Now, I mean, how is he ever going to get wrong these three things matching to each other? Because he just did the three things. So,
to the projectiles that you created when you test fired, were you able to reach any conclusions with regards to this weapon?
I was, like the cartridge cases, I identified the projectile as having been fired from that particular firearm.
So the bullet that you were given, you've identified as having been fired from this Springfield semi-automatic 45 caliber handgun.
That's correct.
Did that end your work in this case?
That ended my analysis from this case. From then, I go ahead and I take all of my notes. The entire process I'm photo documenting. So when I open this up and I was documenting the condition as it's receiving, I'm also taking photos. When I'm doing the comparison, I'm also taking photos of the evidence side by side and any kind of areas of interest that I'm looking at. So from there, I'm going to go ahead and document my opinion and my results on our worksheets. I'm also going to print out all of my photos. I am then going to take all of that evidence. I'm going to hand it to another trained examiner. That other trained examiner, without looking at my results, is going to take all of that evidence and do a comparison himself. And then he'll form his own opinion and then verify that it matches or is similar to my results.
And was that done here?
Yes, it was.
Did that alter in any way your opinion?
Not at all. He was in agreement of my results.
When you talk about the photo, so in your report, you're actually showing all of those characteristics that we've talked about so anyone else could later look at them and see how you reached your conclusion.
It's the photo documentation it's just a snapshot of one portion of the comparison, but yes, a trained examiner should be able to look at them and understand what exactly I was looking at.
So ultimately your conclusion was both those cartridge casings and that projectile that you were provided was fired from the gun you were provided.
That's correct.
Thank you. I have no other questions.
Cross-examination.
all right, let's see how she crosses this guy. I mean, I don't know that there's a whole lot here for her to cross because I don't know that she disagrees that this gun was the gun that fired the round. So.
I just have a couple questions, Your Honor. Mr. Boberg, when did you receive the request to test this firearm?
It was early March of this year.
So March 2025?
Yes.
And then how long after you received the request did you test the firearm?
I was notified that the request was coming in a couple of days. I received the evidence on a Wednesday, which my week wraps up on Thursday, and I did all of the work on that the following Monday, and the report was put out by Tuesday morning.
Okay, do you know what the date that Tuesday report was put out by?
I don't know the exact date. If you'd like, I can refer to my notes and give you that exact date.
Sure, that'd be great.
Okay.
Is that okay?
The judge is like, where is this going?
So the report was authored on March 4th of 2025. The evidence was received in our property and evidence unit on 2/26 of 25, in which I also received them on that 2/26 of 25 and returned them to our evidence room on the 4th of March.
Okay, thank you. And
I don't
who
know where she's
requested
going
you to
with
do
this.
this test on this firearm? Where did your request come from?
This particular request was made from a detective who reached out to me via email explaining could I assist him with a rush. I passed it through my supervisor who allowed me to contact the detective and have the evidence submitted. And then so it was assigned to me because the request was sent directly to me.
Do you know what detective that was?
Detective Duncan.
Okay. And then who did you send your report to?
Once I'm finished with my analysis, my report is then reviewed by another examiner and then a supervisor to make sure that it's all technically correct, and then admin, and then they're electronically released to Detective Duncan.
Okay. And then you said you had done some photo documenting. Were those photos attached to this report?
They were attached to all of my case notes, yes.
Okay. So there's a report, case notes, and then the photo documentaries?
It's all part of, yeah, the notes and the photo documentation is all one.
And how long do you think that report was total?
Oh, it's roughly 13 pages total, 13, 14 pages with the actual report.
Okay. Thank you. So you fired the firearm 3 times, is that correct?
That's correct.
In your testing?
Yes.
Yes? Okay. And then if you were, did you point it all in the same direction when you fired?
When I did my test firing, I was firing into a water tank. The water tank has it's approximately 10-inch thick stainless steel tube with a rest inside of it that I fire it into. So it stays in one place and fires at a specific angle into the water so that I'm not striking anything or being unsafe in any way.
And what's your distance at that point?
Approximately a foot.
Oh, just a foot away into the water tank?
Into the water. Yeah.
Okay. And then did all of the casings go
she
into the
going?
exact same place, like close to the same place?
So around the inlet tube that we shoot into, we have a big net that catches the cartridge cases.
So you can't really tell where they land then, I guess, because the net catches them? Is that what you're saying?
It's land as far as they kind of shoot out of the gun and then get caught by the net.
Okay, so they don't land on the ground and roll close to each other. Okay. But you kind of got a feel for this gun because you shot it, right?
I did.
So if you were to shoot the gun straight and then move 40 degrees to the right and shoot it again, do you think that the casings would end up in the same area?
Objection as to speculation without foundation of.
He shot.
Objection without speculation, without foundation as to. I don't know what the fuck is happening, is what that objection is. So basically, she's saying if you move the gun, wouldn't it leave the casings in a different spot? So, okay.
The gun, Your Honor, I was asking his opinion.
Hold on. He can answer, first of all, if he understands the question.
If I may clarify?
Sure.
So you're asking if I point a weapon, say this way, and then turn this way.
Correct.
Okay. I can't answer that.
Go ahead.
I would expect the cartridge case to be slightly different from the very first one, but not much, depending on what interacts with it in its flight path. Did it bounce off of something? What's the floor type? Or whatever it hits first.
It also really depends on which kind of gun you're using, because some guns basically just barely pop the casing out, and some of them really rocket it. But like if you fire this way, a lot of them put it back into the right. That's the most common, right? Because they usually eject right. And then if you turn this way, it'll eject back into the right. You'd expect them to be in different spots. So
Couldn't say without knowing any of that.
Okay. So would it be safe to say that the casings would end up in the same place if you didn't move and you fired 2 shots?
no.
They should end up close to the same location.
Again, it
Not
really depends
necessarily.
on what is around, because typically when a semi-automatic firearm is fired, the slide comes
Yeah.
back and the cartridge case ejects up and to the right. So if you moved slightly, you're changing that angle slightly. So it could be slightly different. It could be in the same location, depending on how you bounce.
Okay.
Hold on a second. It's
If-
like even with the same exact ammo from the same exact manufacturer, you're just not going to necessarily get that much. It's not going to be that exact because there's a mechanical element to how exactly the bullet, how the casing is moving through it, and not for least a reason how your grip is, exactly how it cycles. So you're not going to get, the exact same projection every single time.
And the
Perfectly.
case is kind of this shape, right? It's a cylinder. And so if it lands like this, it might stop fairly quickly. If it lands on it might bounce a fair bit. So you don't actually know that necessarily. Like this is, yeah.
You could fire it out of a vice, and I'd be amazed if the casing necessarily arrived in the same place every time.
They wouldn't.
Yeah.
You should see this in person. Worst lawyer ever. I'm a local sitting in the gallery. The jury has constant WTF faces. It's wild. I would love to hear from you just as to how the jury's reacting to her, because
I've seen worse, man. I don't know. I've seen worse.
I have seen worse from lawyers. So, yeah.
And and the casing ricocheted off the wall, but then you move the gun and fired it again somewhere else, it could miss the ricocheting of the wall altogether.
Objection
Right.
compound.
Knowing the scene, I couldn't say.
Objection. Don't know what the heck she's asking.
So in your report, I don't want to simplify it because I know that you are a scientist.
Huh.
Is it basically saying that this gun, that those casings came from this particular gun?
My exact wording would be very similar to that. It would say items, whatever the unique identifier is, were identified as having been fired from item, which is the gun.
Okay. This particular gun, correct?
Correct.
Yes. And then you would say that those projectiles also came from this particular gun. Is that correct? Okay. And then
I wonder what his confidence interval is in that. Like, how
This-
confident is he in that?
is that correct?
March 4th is my
made
report
up.
date, meaning all of the analysis is completed and it is done. At that point, my analysis was actually conducted on the 3rd.
Okay. Okay, no more questions. Thank you.
Redirect.
Okay. That was mostly a waste of time, but
I am stunned she wants to ask a redirect question, but okay.
Which side did the casings eject from on this Springfield?
On this particular Springfield, the ejection port is angled to the right and up.
Okay. So in order well, let me ask you this. When casings are ejected and you're not attempting to move your arm or the gun, do they always land right in the exact same spot?
They do not.
Do they bounce and roll?
They do. Again, it's a very violent action. That slide is moving very quickly. A lot of times the cartridge case is spitting, so they could tumble through the air and again, bounce off of anything.
Also, when you're trying not to move the gun when you fire it, unless you are like the Hulk, and the Hulk is not typically known for using firearms, but unless you're like the Hulk, you know, you're gonna move, right? You just do. The recoil moves your arm.
Such as the floor, walls, anything around.
So even as each time you pull the trigger, if you're trying your hardest to keep it as still as you can, does that mean the casings will land exactly right next to each other?
No, they won't.
Where the casings land, does that depend on multiple factors?
Absolutely.
So the type of flooring or ground would be one thing.
ground.
Intervening objects, type of flooring, if it lands on grass, it's probably going to stick or stop, or if it lands in carpet or tile, wood, all bounces differently.
If it bounces off a wall, that would impact where it might land.
Yes.
So having fired guns multiple times, semi-automatics, at your best in trying to keep them together, are they maybe grouped in a general area together?
Typically, when we're firing multiple rounds repeatedly, they tend to generally land in like kind of a pool area. It's not small, but it is a generalized area.
And in a situation where a gun may be slightly moved, that cantering of a gun, can that change the location of the casing itself?
Absolutely. I mean, it's designed, as it's designed, it will eject up and to the right. So, I mean, if you turn it this way, it's up, could change dramatically however you're angling it or turning it.
Guy, this I will go on a side rant here. Do not do the gangsta sideways shooting for so many reasons. But one of the big reasons, well, A, the sights are on the top of the gun. So when you do the sideways shooting, suddenly you're not seeing the sights. But think about, you've got your gun, right? And it ejects back and to the right, back and to the right. And now you tilt it, and now you're firing it on its side. It ejects back and to the gun's right, which is straight into your face. And that brass is hot. I once went to a shooting event where the shooting stage required us to shoot on our off shoulder. So I'm just going to enlarge us a bit here. So what's a good, all right, we'll have this as my fake gun. So I'm sitting there and I'm, firing like this, and then we have to shoot off our, not preferred shoulder. I'm doing this very carefully so I don't slash myself. And the ejection back and to the right was right into my teeth. And so I ended up going to court the next day because this was on a Sunday, and the brass went, and I had little circular burns all over my face. And the judge asked me, Mr. Runkle, are you okay? And I said, yes. Why do you ask, sir? And he's like, you appear to have marks on your face. And I said, oh, that's from shooting, sir. And he said, I don't have any more questions. And I went, okay. So, but like, it was noticeable. It was really noticeable. And so, yeah, don't do that. You're not going to enjoy your experience doing that.
When you are talking about casings and where they land, even if you go and see them, are you able to look at them and say that was from shot number 1 or that was from shot number 2?
Oh, no, we just generalize an area of where a shooter might have been.
And again, that's just because they're landing at best in a pool area, even if you're trying to shoot as straight and uniform as you can.
That's correct.
Even if you had it like locked in a vise, it's still going to have some
Any
differentiation.
questions for this witness from any member of the jury? I see at least one coming down.
And the jury gets to ask questions. That's fun.
Can we vote now?
Yeah. Can we, what did I do? Apparently it just stopped. Oh.
Multiple rounds repeatedly, they tend to generally land in a kind of a pool.
All right, I have a question from a.
All right. There's another one there. Could I have worn a balaclava? Yes, I just didn't think I would need one, so I didn't bring one. And somebody else was mentioning casings going down shirt burns too. Yes. So this is an experience you will eventually have if you shoot a bunch, which is eventually you will have hot brass exit the gun and go down your shirt. Now, this is a problem that tends to happen mostly or more often to women. Why? Because women often wear cleavagey things, and cleavage is really good at catching hot brass. So there are a lot of women shooters I know who will tell you, I haven't asked to look, but they will tell you that they have a particular burn right like dead center where the sort of cleavage tends to focus things. So, what I always tell people who are, new shooters is dress dress defensively. Dress in a way where you don't have any open, keep your collar, pinned, keep your boots, whatever, because it can, brass can land in places and that will suck. So, now it will eventually happen to you. And the thing is that hopefully you've got enough experience shooting that you can deal with it appropriately. Because if you end up if you are suddenly having a hot thing down your shirt, the appropriate thing to do when you're sitting there, you're like, all right, and bang. And then suddenly hot thing down the shirt, you're like, gun down is the first thing. And then panic. But you don't want to do the, oh my God, there's a hot thing while you're still holding the gun. Because that is a good way to have a very bad experience. So somebody says, is swearing appropriate? I would be shocked if you didn't. So, yeah. All right. So they're vetting the jury question here. He's like, can I answer this? And they're like, no. Vetting the jury question. Also, don't be a brass goblin at the range. taking other people's brass without permission.
All right, I have a question from a juror. Where would the casings go if the gun was held sideways?
Just for
Oh my God. The jury actually asked about gangsta style.
clarification, sideways either way.
Why don't you tell us for either way?
So if I was to cant it sideways and the butt was down, it could potentially go up and fall to the left side because of the way the gravity would be. However, if you turn it this way, it's angling it further down. And again, it depends on how it hits the ground, what it can bounce off of.
All right, any other juror questions?
It's like, do we have any intelligent
Follow-up
jury
from the defense
questions?
based on that question?
No.
State?
No, Your Honor.
All right, sir, you can step down.
Thank you.
Thank you. State can call its next witness.
You there.
All right, so that is the firearms expert. The thing is if there was a lawyer on this file, they probably could have skipped this because I don't think she disagrees that the gun was fired from the same thing. They probably could have just stipulated to that and moved on. This is why having a lawyer on the file tends to make the trial go a lot faster. He's saying, have you seen the ouchie belt that Lori has to wear? Yes. I'm not going to pull up the clip, but she's wearing a shock belt that if she does something improper, will give her 8 seconds of very unhappy time. So, yeah, that not what you want to have happen to you, but yeah. All right. So let's wrap up with a fun little side trek into the adventures of lawyers who should know better. And yeah, that's always a fun place to be, right? Because so let's just see. Now I'm just trying to give me 1 second. I'm going to switch over the things so it doesn't echo. There you go. We should be echo free. All right. So what ends up happening in this case is that they cite some law, and that law that they cite turns out to not be law because apparently they were using some probably ChatGPT or something like it. Maybe they decided to use Grok or something like that, but yeah, they decided that they were going to do some things and it didn't work out for them in the slightest. So, let's sort of have a look at, I guess, the reverse order first, and then we can go, we'll sort of go in reverse order there. All right. So, why? Come on, StreamYard. Show me the thing. There we go. All right. I'm told I need to swoop. So, swoop. So, what does the case say? In the Court of Appeal, 5th District of Texas at Dallas, they note, after reviewing the parties' briefs, we note that appellant's May 16, 2024 brief cites the following cases, none of which could be located by appellee or this.
Oh dear.
Macy's, Texas, Stevens versus Beard, Gaston versus Monroe, and a state of Malpass versus Malpass. Additionally, appellant's May 16 brief does not contain a certificate of compliance or a signature of the party or counsel who filed the brief. We ordered the appellants to file with this court copies of the case listed above and to supplement their May 16 brief with a certificate of compliance and a signature of the party or counsel who drafted the brief. Within 10 days, they're like, we need to know who we're going to punish. That's why they want the certificate and the...
And this is the part where he trumps to be like, haha, silly court. Here are the cases. I don't know why you couldn't find them, but here they are, you idiots, right? That's what happens next?
Well,
No?
we don't know what happens next, but what I suspect... Well, the really dumb thing they could do is if they turn around and fake the cases, because that happened in a previous case where they're just... in a previous...
Wow.
In a previous case, they asked ChatGPT to produce the case. And so
I missed that story.
It produced a case.
I missed that story. That's great.
But this one, we don't have an answer. I can tell you what I would be doing if I was the lawyer. I would be saying, I used AI and it generated some case law and it appears that those cases don't exist. My bad. And I will accept whatever punishment the court feels it is appropriate to impose. That is the smart move when you are just like, I screwed up. I am going to take my lumps now because the only thing that can happen from fighting this is to make it worse. But let's work backwards, because this is the this was the response brief that and how they dealt with it. They note Texas law does not support the daughter's arguments. The notice of gift was sufficient to complete the gift. The court should reject the daughter's arguments on Texas gift law because they rely on cases that do not exist. The daughters cite the cases listed below. After a diligent search, JGB could not find the cases. Macy's, Texas, the same cases.
I remember my common law intent, delivery, acceptance is for a gift. I remember that.
That's the same as here.
Wow, amazing.
So, guys, one of the things, chat, one of the things that often comes up is like, let's say Kurt and I have a falling out. And we don't like each other anymore.
I like talking to you on the phone though.
This is hypothetical. It's not like a real scenario. And let's say I've
leave me now, you take away the very best part of me.
Oh, God. So, let's say I have given Kurt, I don't know. I gave him a Tesla. We'll pick something, uncontroversial. Nobody could be upset at Tesla right now.
Oh, I actually saw a phone call recorded on this exact point recently. Okay, so there was a guy who called this. There's a YouTuber who buys and sells cars, and this guy called and said, I bought my girlfriend, what did he buy? Something really expensive, some really expensive Mercedes or something, and I want to trade it in for it. It's like I bought it for her. And the guy asked, like, whose name on the title? And it's hers. And it's like, oh, yeah, no, I can't buy it from you because it's in her name. And so the call was great. He's like, so you mean just because I bought it for her and her name's on the title, that means I can't sell it? Yes. Yes, that's what it means. But I have all the other paperwork. I have the bill of sale. I have the receipt, and my name's on all the other paperwork. Yeah,
the title. Yeah. But then it becomes a question of, did I mean to loan Kurt the Tesla, or did I mean to give him the Tesla? Because this comes up all the time. It especially comes up in like romantic relationships when they dissolve, because they're like, people will say like, I only meant to loan her that engagement ring or whatever else.
It's interesting on law.
I actually saw one that was interesting because the guy claimed that he was trying to loan his girlfriend.
I've never seen the loan one. Conditional gift is the more common argument.
For
some
engagement rings,
some
you get
states buy it,
conditional
some
gift.
states don't.
But I saw a case reported, and maybe I should dig it up sometime to talk about it. But the guy said that he was loaning his girlfriend a collection of lingerie and
love it,
private toys.
Mm-hmm.
And the court was like, we do not find that this was a loan. we find that this was intended to be a permanent transfer because, yeah. So, yeah,
How do you rent out toys? How's that work in terms of cleaning and re-renting? And I'm not sure that's a viable business.
Yeah, the court was like, yeah, no, you can't actually have that. So in terms of like what makes a gift, first, intent. And so intent can be pretty significant because intent is like, did I mean to loan this to you or did I mean to give this to you? If the neighbor comes over and is like, hey, can I have your lawnmower? The court is probably going to find that I intended to loan the lawnmower to the neighbor and not to give it to the neighbor, right? Because that's the more common thing. But, and this can get complicated. Did I mean to, like a piece of property? Did I mean for them to just live there? Although property often has formal transfer requirements. You can get all sorts of questions on this, right?
Yep.
There's a piece of art. If I, transfer that piece of art to Kurt's house and he has it on the wall, and later I'm like, hey, Kurt, I need that art back. It's, worth $50,000.
Or maybe
and I
these things, which you gave me only as a loan.
Exactly. If I come back and I'm like, hey, I want that back, the court would be like, really? The thing that has Kurt's monograph on it, like that has Kurt's symbol on it, you want that shit back? No, so the court will look at intention, and they'll often have to infer intention from circumstances. What kind of object was it? What was the, context around it? Sometimes there can even be things like text messages where like somebody says to their girlfriend, hey, I'm going to give you my old car. And it's like, well, that says you're giving it. It's not a loan, right? So you've got that. And then you've got the issue of, was it actually delivered to the person? Because typically a gift is not complete until it actually ends up in Kurt's hands. So let's say I tell Kurt, I will give you, $50,000 for nothing, just as a gratuitous gift.
Aww.
And Kurt's like, yay. And then later I'm like, hey, Kurt, I was real drunk and I'm not actually giving you the $50,000. Kurt would be like, I'm sad, but he probably can't sue me on the expectation of the gift because the gift is not completed. But if I actually drive over to Kurt's and I give him a sack of money that is $50,000 and he's like, awesome, then I'm probably not getting my 50 grand back. And the last thing is acceptance, right? Because I can't let's say I have let's say I've got a piece of land and that piece of land happens to be contaminated by an oil leak and lead and mercury and mutant rats. And so the government has told me that I must clean up this land. And I'm like, oh shit. And it's like, okay, this land is a giant nuisance now because the government is like, it's going to cost you $1 billion to clean up this land. I'm like, I don't have that. And so I can't roll up the deed to the land and stuff it through Kurt's mail slot and be like, your problem now. Because the first thing he'd do is be like, I don't want your giant nightmare land nuisance. No. He would reject that gift. Similarly, if I drive up with a car and the car is literally on fire and I'm like, Kurt, brand new car, he might be like, get that shit off my property. In which case I probably, we probably have not completed a gift because Kurt has not accepted the gift. That one doesn't come up that often, but it could matter. So, anyway, this case is all about whether or not there's a gift of various land and jewelry. And in this case, they're saying, listen, the jewelry wasn't actually transferred. Just because you promise the jewelry doesn't make it a gift, which actually seems to be pretty basic B law.
It's pretty basic law.
So, what did they say about law of gifts? So, give me 1 second here. I'm just pulling up where they argue. Now, I'm just going to note here as well that they really ought to have known better on this one. Because, like, as a lawyer, you should know things like the law of gifts.
Yeah,
And
it's basic.
I am a criminal lawyer. I know this, right? So, Texas law regarding gifts, they say, unlike contracts or commercial transactions, gifts in Texas do not require consideration to be valid.
How could a gift possibly require consideration? Do you
This
know
is
what
the first-
do you know what a gift is?
So, folks, for the chat who doesn't really know, like, who may not know contracts and so forth, a contract requires consideration, which is that if I am giving, like, if we are having a contract, I provide something to Kurt, Kurt provides something back. There's consideration on each side. Obviously, a gift doesn't require consideration because it's a unilateral transfer, right?
Yep.
So Texas law recognizes gifts as valid transfers of property that do not require consideration to be enforceable under common case law.
Sure.
I mean, sure, but also stupid. How do I put this? This is like saying that this is the kind of obvious statement that is like saying that Coca-Cola should not normally be served to you in a restaurant on fire. And you're like, yes, that is true, but also idiotic to say. You know, if that makes sense. So they say, you know, Macy's, Texas, wherein the court affirmed the validity of a gift by stating a gift is a voluntary transfer of property by one to another.
You convinced me several sentences ago. You can stop talking. That's what I'm thinking to myself right now.
But here's the other thing that just should have been a very small, subtle clue on this one. Macy's, Texas Incorporated versus D.A. Adams and Company. I just want to say, how many gifting scenarios do you imagine involve Macy's Incorporated?
Also, I don't need a cite. I already know this.
Yeah, but it's still like this citation should have obviously been a problem. And then they cite further in Stevens versus Beard, they discuss the elements of a valid gift, emphasizing the importance of donative intent, delivery, and acceptance. Okay, that's again basic. Court did not mention consideration as a requirement for a gift.
I already know that.
But here's where we get into other more problematic stuff. No actual or physical transfer of property needs to occur. That is actually, you just said the opposite. Delivery.
Yeah, it was in the thing that you just said 5 seconds ago.
Yeah, they just finished saying delivery is important. And then they say no delivery is necessary. Which is it? Is delivery important? Or because this thing of actual or physical transfer of property is the delivery element. So I would expect that, like a law student of ordinary intelligence and ability, or even subordinary intelligence and ability, like even a law student who has just suffered a concussion, I would expect to be able to spot that there's a problem here. This concept of constructive delivery allows for a gift to be valid in Texas, even if there's no actual physical transfer of the property. Constructive delivery occurs when certain actions or circumstances demonstrate the donor's intention to transfer ownership of the gift. So, okay. I'm just curious to see whether constructive delivery shows up anywhere.
Well, for land, you can't really deliver the land. So for land, there's going to be some other kind of role. Probably delivery of the deed, if I had to guess.
Yes. So constructive delivery is when you hand over a representation. So
like the deed, for example?
Yes. Like I hand over the deed. Or the other example might be, you see the commercials or the movies where people, I don't know anybody who's actually been given a car by their parents. But like you see, let's say I suddenly fall into a ton of money, and for some reason I think Mrs. Runkle wants a car, which is not what I think she wants, but let's imagine that. I give her the key to the car. That could be constructive delivery, wherein I don't actually have to hand her the entire vehicle, right? So they note Gaston versus Monroe. There was no formal deed or physical transfer of the property. So they said that she had done everything in her power to pass title to the land to her niece, including expressing her intent to gift the property and acknowledging that her niece's ownership publicly. Yeah. So, did you pay for the jewelry? It was a gift. When did you get the gift? What year are we in? 2023, somewhere around 2016. Were there any discussions with your mom about when you would be taking the jewelry from her house? Taking? No, it was a gift. If somebody says, I'm giving you something as a gift, you should take that thing right away. Make sure delivery is complete so that then you're done, right? So let's just give some really important tips here. Tip number 1, if you are a lawyer, there are the following uses for ChatGPT. Don't.
I've used it to rewrite like prose to clean up like language on rewriting a argument before, but
I've done that too. I've been like, this sentence is clumsy, please rewrite, and it'll rewrite a sentence. It can also be useful for things like, here is a list, please format this list with bullet points. It's great at formatting shit. But anytime it's actually doing legal research, you are in terrible places. So there's a question I've asked of all of the different, AI things that I could find. And it's a really basic question. It is, which case is the primary Supreme Court decision on how to conduct a Section 74 Firearms Act hearing in Canada? And you know what they all say? They all say that there is no such case and that the only one that applies is the firearms reference, which doesn't. It mentions Section 74 in the firearms reference, but it's not a case about that. It's just describing it because it's a case about the Firearms Act in general, and they mention that particular section. However, there is a case that is the case, and that case is Ziolkowski. And anybody who took my firearms law course should be able to answer that question easily. But ChatGPT and Grok and all of those fail at it and will generate the wrong answer. I've also asked them questions like, please write me a brief arguing arguing for the legality of, plastic brass knuckles. And they will come out with bullshit. They will come out with gibberish. I see. That's conceded, Runkle. Oh, I figured you were referring to Runkle v. Alberta. Runkle v. Alberta is not a Supreme Court case, so that would actually be an incorrect answer if it had spat it out. However, I am citing Runkle v. Alberta in my Supreme Court leave application in the case of Runkle v. Canada. So, and it's not a stupid citation. It's actually a highly relevant citation. So I did cut out the language that I was originally going to use. Kurt, you may fault me for cutting this out. I initially said, how did I phrase it? It was something along the lines of, ironically, the case that should guide the court here is the case of Runkle v. Alberta. And I cut out the word ironically, which is probably the right thing to do. But I did still say that the case that, should guide here is Runkle v. Alberta.
it's the best case by only the most handsome litigant.
I didn't put that part in, but it is actually the best case on the issue. And so, yeah, we'll see. But I don't know why lawyers keep doing this, but they do. What's the difference between versus Canada and versus King?
Good question.
So the versus what you'll get is, in some cases you'll get RV Bob, and that is the King and Bob, and almost always that means that Bob is being charged with a criminal offense. So that's the key thing. Was the U Runkle in that Runkle v. Alberta? Yes. There's only one Runkle family in Alberta, and it's me. So, sounds like a professor selling their own textbook. It's literally one of the very few cases that addresses a very particular issue. So that's the thing, is I litigated a very specific case. Can we read the case? I don't think we can read the case tonight because we are 4 hours in. Chat, next Monday, do you want to read Runkle v. Alberta?
You know they're going to say yes.
I do.
No, we have no interest in that, Runkle. That sounds dumb.
I'm just trying to pull up how many pages that one is.
Chat, you need to say no. Don't humor the man. Vote no.
I suppose they could do that. I suppose they could say, so it's Runkle v. Alberta, Runkle and Alberta brackets chief firearms officer. It is not that many pages. It is only 40 paragraphs. So it's not too long. But yeah, it's a fun one. How about Wednesday? I could possibly do Wednesday.
Get
Somebody
everyone prepped
says
for that Karen Reed trial, which looks like it might start Thursday now.
I hear Thursday. I hear next Tuesday. I hear all sorts of things. I just dropped the link in the chat in case people want to check it out.
I would just want the Karen Reed case to start. I want the clown show to start again.
It's gonna be.
We're gonna have fun. We're gonna have funnel cake. We're gonna have face painting.
I've
we're
never
gonna
actually
have balloon,
had.
We're gonna have
Funnel
balloon
cake.
animals. Funnel cake kicks ass.
I've never actually had funnel cake.
You are missing out, man. You are missing out.
Also, Kurt is the only person to ever drag me to a Waffle House. So the one and only time I've ever been to a Waffle House was with Kurt.
You had a good time.
It was actually a pretty good time. I mean, I was like, all right, this is actually a really solid breakfast.
I know, right?
I'd go back to Waffle House.
Yeah.
So
I wouldn't steer you wrong.
And although I've heard that is it the case that the Waffle Houses are asking for like $1 extra for each egg you want?
I'm sorry?
I've heard that Waffle House is charging extra for eggs.
Yes, they are. They charged a 50% increase recently. 50 cent increase, sorry.
Wow.
Yeah.
Okay. Here in Canada, we have like plentiful eggs. They're not super expensive. So what is a funnel cake?
A funnel cake is basically just fried dough. You take just like pancake batter in basically kind of like a string. And so you just pour the pancake batter like in a string kind of format in the oil, and it fries. And so you kind of get this nest of like pancake batter. And then you usually put powdered sugar on it. Sometimes you can put like fruit on top of it as well. Very nice. Simple carnival food. Outstanding.
I like all of those things.
Yeah.
I like pancake batter. I like oil. I like powdered sugar, and I like fruits. So that actually sounds amazing.
Yeah, strawberry or blueberry. Sometimes you get chocolate on it, Nutella. Very nice.
Now I'm like, I need a fare like right now to go try this out. And I see we hit 2 out of 10 on the goal. Goal ended. And we are at 4 hours in. So I think we're going to wrap it up here. Oh, wait, we're not going to wrap it up. We got 60 super chats to read. So we're going to not wrap. We're going to go back and, have a look there. I see people saying I must try funnel cake. Kurt, you are welcome to stick around. You're welcome to duck out as you
No,
wish.
I'll stay for a second. I just want to keep people apprised of some stuff I'm doing in case
Oh,
I forget
awesome.
later. So obviously I'll be doing the Karen retrial. So you should definitely tune in for that. And also I've mentioned I am trying to make watches. So I did a little unboxing of the stuff that I got so far relating to making watches. I got my movement, my case, my dial, my hands, and
It's not that kind of movement, folks. I know what you're thinking. Chad has a dirty mind. So
okay, yeah. And anyway, so hopefully this upcoming weekend I'm going to try to assemble my first watch. It's going to be exciting. So you can tune in probably on Saturday for that. And I got a logo made. It just says the word Beefish in a silver metallic, so I can put it on the dial, so it can be from the Beefish Watch Company. Exciting.
Nice.
Yeah.
So all right. So I'm just looking here.
This is going to be mechanical. This is an NH35 movement. So this particular one is, I thought I'd start out with sort of the basics. So the NH35 is probably the most popular movement, like basically ever, for an automatic watch. So this is mechanical, automatic, using a Seiko NH35 movement. It's going to be great. If it goes well, we're definitely going to have some quartz ones in the future. I'm a big fan of the VH31 Mecha Quartz movement. So that's going to definitely be a thing. I've been looking into watches. I have more things selected in my cart. I'm ready to go.
I may have to make a watch strap for that at some point.
Yep. Absolutely, 100%.
And what is it? Dateslav Act Mankari says, can't make it live, but we'll catch the rerun. Thank you so much. Roketsu, thank you for the YouTube membership. Much appreciated. Tony P, thank you for the 5 gifted memberships. Amanda Beach Life, welcome aboard. Thank you. Anon Mouse, starting with some cheer. My parents' 47th anniversary is tomorrow. Congratulations to your parents. That's amazing. Still as lovey-dovey as ever with love, devotion, and work. It can be done. It can. You'll hear the stat about like half of marriages end in divorce. Well, that means the other half end in death. The other half are to death do us part. So, Yep. Rainman YYC, thank you for the gifted memberships. Much appreciated. Against the Tide, please like to help Runkle reach his pro bono goals. Thank you. Roketsu, you should check out Blueprints. It's a roguelike puzzle game, and it's amazing. Just finished the story. Now I'm solving all the secrets I missed. Go in blind because that's the fun of it. All right. I'm going to wonder. That's got to be on Steam, right?
Mm-hmm.
Oh, Steam is trying to sell me Path of Exile 2. Is that game that Elon sucks at?
Yes, for the person who asks, it's a brand new case. It's all the parts are new. It's going to be great.
You're looking forward to it?
I can even dig some of the stuff out. If you give me just a second, I'll show you some stuff while you're reading super chats. Hold on.
Sounds good. Phoenix, member for 27 months. Thank you so much. I talk about Bruno. Been a great 14 months, Ian. It has. Good to see you. Lady Fang, did you know that Australia is the only Western country that doesn't have a Bill of Rights? That is interesting and terrifying. Jackie Lindy, funny how if you give your citizens rights, it limits what you can do to them, almost like it's a good thing for the citizens. Give them more. I'm a big believer in limiting the power of government, but I know that not everyone thinks that. So Auburn Warfare, thank you so much for the YouTube membership. Much appreciated. Apocalypse DOA, so Canada's basically your spouse. No, my spouse actually likes me. Auburn Warfare, where's Runkle's goals? Here's to a gin. I have been bad at goals, and we're bad at actually accomplishing the goals today, so it is what it is. Maybe I was just picking shit goals. Nick Levi, so Canada's Section 33 is like Star Trek's Section 31. Extraordinary measures means all options are on the table if they feel like it and don't tell. There are some limits, like they can't actually suspend elections. There's a bunch of things they can't do with it. So, Yeah. Kale Pegasus or Kale Pegasus. What is a pseudo Caesar? In this case, Clamato. I had beer instead of vodka, lime juice, Worcester, and some soy sauce was what was in that. David Craig, have a pseudo drink, sir. Thank you so much. Auburn Warfare, yay, you have a goal. P.S. How do I send you M&S goodies from the UK in a non-creep way? My address is in the About section. So those can be sent. Rainman YIC, notwithstanding Section 7, public servants found in corrupt activities shall be sentenced to grizzly bear, sentenced by grizzly bears. Oh, that's the watch case?
That's the case.
Nice.
Yeah. It's got date cyclops, so it makes it easier to read the date. So that'd be nice.
That should be pretty nice to see there.
And then here is the watch dial and the bezel, and I can make it look kind of like it will in the watch, so you can kind of see how they look together. Yeah. So you get this purplish dial there.
Oh, nice.
You get this purple dial, and then the bezel of the watch is black with purple markers on it, so it kind of matches. So there's 12 o'clock. So you get that sort of pearlish look with the black, with the purple markers. I thought that'd be really cool. And then I got myself some very miniature watch hands. You can't even really see them, but there they are.
Don't lose them, because you will never find those.
So yeah, I got myself some toys.
Sounds good. Hopefully not the
Nah.
And Charlene Anderson says, "Can everyone wish my mom a happy 90th?" Happy 90th. That is amazing. Still lives independently and is sharp as a tack. That is awesome. So congratulations. And Joy W says, "Can I write your name on my ballot? Runkle Terrier for the win." Please don't, because that just would wreck your ballot. They will just throw it in the trash. So yeah. PJ Wolfweimers, glad to be here. Glad to have you here. Jackie Lindy, Runkle, it's fine to call it how you see it turning out, just because we mostly don't want to see Karen Reid convicted. Still important to keep in mind the possibilities. I agree. And I don't think she should be convicted, but we'll have to see how they get on the trial. And maybe the trial convinced me that they proved it beyond a reasonable doubt this time.
Good luck.
Good luck, because the evidence is kind of, contaminated, but yeah. Mostly harmless fuzzball says, under Runkletarianism, the sole definition of gun control will be keeping your group small and on target. Fair. Caitlin Moore, happy to be here. Hi everyone. Bye Monday. And I mean, I'm not a believer in necessarily like free for all whatever, but our rules are dumb. So Victor Man 777, Turtle Boy can't watch the broadcast if he's sequestered. He should probably, I hope he wins his application. I understand he does have an application to for an exemption there. Lady Fang, I'm looking forward to Alessi versus Trooper Paul. The stop, he's already dead comes to mind. I don't know what they're doing with Trooper Paul. I mean, I know what I would be doing with Trooper Paul.
Well, Trooper Paul is there. It's his mentor that's there now, right?
They still got Trooper Paul on the witness list. So, and I suspect that's because they know that there's going to be an issue. Like, they're going to have to explain that they did 2 analyses, and how do you reconcile those, right? So I feel like that is a thing that they got to settle off either way.
Proctor, of course, is the bigger problem because he's so discredited. So, and what do you do? What do you do? You don't call Proctor. How do you not call Proctor?
I have several things I'd like to call Proctor. But I mean, they're going to have to call Proctor, and they're going to have to try to their best to like save his evidence.
Good luck. That should be entertaining to watch.
Right? It should be a mess, but Shay B says, for the goal, thank you so much. AG, how my hands doing finger drills and listening. That is for, stenography. Cad Monkey FPV, can't drink, so might as well live vicariously through the Runkle. Free Karen Reid. Cheers. And thank you for the membership there. Much appreciated. Mr. Meathook, Ontario, Perry Sound, home of Boston Bruins, NHL greatest of all time, Bobby Orr. Awesome. Also, I might be in Vancouver in July. So if people wanted to we could do a thing there. So that's a possibility. The bathtub unalive turned law student sounds like James Ham's story. Ham was convicted of removing someone in a drug deal gone bad, got his BA in prison, got out, attended ASU law, and passed the bar. Denied on character and fitness.
Yep.
Ouch. That's a lot of work to get denied. Sergeant Bukaki's tainted evidence. If every M after the first is free, it sounds like it'd be time to look up the local SO registry. Would be a great comm for requesting parole. Probably not, because they'd actually view that as worse, not better. Sergeant Bukaki's tainted evidence. Whoops, I'm an hour behind. 2 times speed time. Rain Man says the kicker is that this guy is an Elections Canada employee. Yep. Shay B says, good night, y'all. Good night.
Good night.
Victor says, sent a DM about the lawyer behaving badly. It was the case I was planning on talking to, but thank you. It was very helpful. Jackie Lindy, Ruggles drunk in Kurt's 7-Eleven, and here I stand with a packet of Mentos and a bottle of Diet Coke in the Twinkie aisle, ready to light it up like the 4th of July. Maybe don't. Rosie says, yay, I missed you last week. Runkle equals best time. Good to see you, Rosie. Vomit Fountain says, I'm late. Please accept my delayed support, and I'll catch up in the replay. Good to see you. Patty Hoffman says, lucky time goal. We got ourselves a lucky here. Conacy, thank you for the 5 gifted memberships. Lady Draconis, thank you for 10 gifted memberships. And much love to you folks. Thank you so much. Rainman says, therapy fun for Ian's hoplophobia. Because apparently I'm anti-gun. Vomit Fountain says, got to support a lucky goal. Thanks for a fun Monday stream. Glad you had the time to do it. Thank you. Nicholas Starro, bonjour. Je vous souhaite and bonne journée. That is good day. I wish you a good day. So, David Craig, justice for Bob. Bob knows what he did. Kimchi says, motion to compel lunch with Brennan. If I was going to pick one to have, Brennan would be far down the list. Rainman YIC, CRA, easy file form T4X. How much did you make last year? Send it to us. Witchy Girl Games. Even when I disagree, I appreciate Kurt's input. That is good.
You know, I figure as long as you can try to follow my logic all the way through and it makes sense, then I'm doing okay. But then I get mad or irritated when people are like not listening to me or not. You know, just
you really don't like it when people ascribe a view to you that is not your view. I've noticed that.
Yeah, that gets very irritating.
And you're like,
even if I spend like lots of time like trying to clarify it, and still it's like it doesn't work.
The thing is, when you get into that, you cannot fix it. Like there is no clarification that. Because the more you explain, the more they will just justify their own views, and you are, it doesn't help. So
yeah,
it's just like, sometimes you just got to give it up and just sort of go like, well, it is what it is. So
I responded recently by just putting a filter on my end that I don't even see messages unless they're from members or super chats anymore. So now I don't even see the stupid. So that helped a lot.
Okay. Well, Jamie F says happy Monday. Kimchi says, Kurt, you're hilarious and I always appreciate your point of view. You're a great presence on LawTube and in general. So good stuff. Michigan Farm Boy says to validate the lucky, because I opened the lucky, notwithstanding that we didn't reach the goal for that. Layla J, thank you for the YouTube membership. Much appreciated. Rob Price, considering most handgun manufacturers use 4-foot blanks and a lathe that makes them rifling. So in theory, you could have 8 barrels with the same rifling. Beretta showed this in a video years ago. Interesting. Laura Riker, you should see this in person. Worst lawyer ever. I'm a local sitting in the gallery. The juror has constant WTF faces. It's wild. I wish I could. Just because, says the confidence is from the merkin below his lips. Ouch. Matilda says, good morning, 6:12 a.m. from the Netherlands. Good morning. I've never been to the Netherlands, but I would love to. Light Queen, thank you for another fun Monday. Thank you. Witchy Jesse, 9 months. It's been great. 19 months. Conacy, hard to believe it's been over a year. Good to have you. Equality, don't be mean to Bob. Bob knows what he did. Hog Banana, no. Any chance for a Bob knows what he did shirt in the Runkle merch shop? maybe I could see possibly doing that. So we'll have to see. Good Kimmy says, hello, Runkle. Hello. Good to see you. All right. I think we're all caught up. Yeah, we will just sort of wrap it up here. I'm still not 100% in terms of being healed and healthy. As it turns out, driving for 16 hours is a great way to get sick. And so I got sick, and I'm still trying to recover from that because I don't recommend the 16-hour drive. It's a bad scene. So all right, let's wrap things up here, and I will see you guys soon. Maybe Wednesday, maybe next week. We will see. But yeah, I see somebody says Karen Reed's going to be a slog. It is. It's going to be pretty rough. So, all right. Good night, everyone.
Bye.